Lordship. I beg to mention for item number 28, Your Lordship. The matter may come up for next weekend.
Right.
I could not receive any instruction from
What
the
instruction is required? It's a bail hearing
interim order is there, Your Lordship.
or whatever. CDS come,
CDS come.
CDS come, you do the matter.
Personal difficulty is there.
Whose person difficulty?
The conductor advocate, Mr. M.H. Chaudhary is not available here. Mr. M.S. Chaudhary is not available, he will do the matter.
Lordship, here, Lordship, we will also have to update the CD, Lordship, because his statement is not in the CD. Whether
Okay, on the prayer of MS so and so, Leonard Council, what is your name?
Hey, Begum.
On the prayer of MS, you are there in the case.
My lord, my conducting advocate.
On the prayer of MS A Begum, the Leonard Council. Let the matter be listed. How much time will it take for update?
from Sri Bhumi, Lordship, 11th September.
Okay, let the matter be listed on 11 September. The Leonard APP submits that updated CD will be required.
Oblige, Your Lordship.
May I please, Your Lordship, may I pray for listing of a matter regular bail application for tomorrow, my lord? May I pray for listing of a regular bail application for tomorrow, my lord?
You, huh? You go to the senior banks.
Nine.
What number nine?
But best to mention item number 2, matter. Kindly withdraw the petition matter. I got instruction from the client.
Hmm?
To withdraw the petition matter. Item number 2.
Your name?
J. Abbas.
On the prayer of Mr. J. Abbas, the Leonard Council, appearing for the accused applicant, the instant bail application is dismissed on withdrawal.
Flashman.
May it please, my lord. My lord, I beg to mention item numbers 10, 11, and 12. Connected matters, my lords. I have been newly engaged in the matters on behalf of the petitioners, my lords. We get to receive the files. I'll file my power also in due course, my lords. With the consent of the other side, I'm praying for the matters to be listed on 17th September, my lord. It is a Thursday.
Okay, on the prayer of Mr. B. Chaudhary, the Leonard Council, appearing for the petitioner, which is not objected by MS
K. Burwa.
K. Buru on the Leonard
Harassment
Council.
number 2 to 13.
Leonard Council, appearing for respondent number 4 to 21.
4 to 21.
Respondent number 4 to 21. Let the matter be listed on 17th September.
There are interim.
10, 11, 12. Huh? Interim order so passed earlier, shall continue.
Lordship,
to the
one
next application.
affidavit may file to
Yes, ma'am.
federal-
File it within the- within-
it's our
before the
before-
next-
In the meantime, the Leonard,
before the date.
no, what affidavit?
Additional affidavit, my lords, to bring on record certain facts, my lords. I'll file it before the date of.
Okay, Mr. B. Chaudhary submits that he would like to file an additional affidavit in the instant case. Let the additional affidavit be filed by 17th September.
Deeply appreciated.
May I please, Your Lordship? Your Lordship, I beg to mention item number 18. I have taken consent from the other side, Your Lordship.
Item number 18
18, Your Lordship.
is what happened?
Lordship, due to some personal inconvenience of my senior counsel, Your Lordship, may
Okay,
be taken off in the month of September, any convenient date, Your Lordship.
I appeal for the respondent.
Hmm?
I appeal for the respondent.
okay, your name?
S.A. Hussain, Your Lordship.
Huh?
S.A. Hussain, Your Lordship.
Item number 17,
18, Your Lordship.
18, okay. You are not there in the case?
Lordship, my name is there, Lordship. S.A. Hussain. Your
S.A. Hussain, okay, okay. On the
Lordship.
prayer of Mr. S.A. Hussain, the Leonard Council appearing for the petitioner, which is not objected by Mr. S. Nawaz, the Learned Council, appearing for respondent number 2. Respondent number 2, let the matter be listed on 18 September. 18 September.
Deeply obliged.
Interim order may be continued.
Interim order so passed earlier shall continue till the next.
May it please, Your Lordship, I beg to mention daily list item number 16. Lordship, 16, with the consent of the other side, Lordship, kindly pass over the matter for the
On the prayer of Mr. Your name?
MD Imdad.
You're not there in the case.
No, Lordship.
Then
My name is Tom. On behalf of F. Hussain.
Mr. So and so on behalf of Mr. F. Hussain submits that praise for adjournment of the matter. You are appearing. Adjournment of the matter. You have taken consent of the other
Yes,
side. You have
sir.
intimated them.
Yes.
Let the matter be listed on 23rd September.
Lordship,
23rd
interim
September.
order passed earlier shall continue.
Interim order so passed earlier shall continue to the next date of listing. He submitted that he has already taken the consent of the council appearing for the other side. Like that.
And Lordship, item number 22 also, Lordship, CD not received.
22 CD not received.
CD not received, Lordship.
Okay.
22 and 23, Lordship, same matter.
Huh?
22 and 23. Connected
22
matter.
and 23.
But council are different docs.
Mr. Receipt is appearing in the other matter.
Yes.
Okay, 22, I write his name, then say that CD is not received, let the matter be listed. When?
Lordship, 11th.
11 September. And 20.
Oh, BA, Lordship, so let it be before, Lordship.
Huh?
It's a bail application, Lordship, regular bail. 7th, Lordship.
Give it some 7 September. 23 also go along with that, huh? 23, you don't write anything, and then list it along with that other matter.
Much obliged.
Item number 36, my lord.
Hmm.
Perhaps case diary is not available, my lord. The petitioners are on interim, my lord.
Case they not received.
Okay, where 36, you can write, yes, Nawaz is present, CD is not available, let the matter be listed on
11th, Lordship.
11 September. Interim order so passed earlier, shall continue till the next date.
Deeply obliged.
May I please, Your Lordship, I beg to mention item number 29. Case diary is not available, Lordship.
29 also, right?
I am on interim, Lordship.
Parties are duly represented, then CD is not received. Then interim order passed earlier, shall continue.
Obliged.
Lordship, item number 52, the senior will not be available today. So it's requested to be fixed on 24th August, Monday.
29, 11th. 11th. 50.
52.
Okay, on the pair of the learned counsel appearing for
Petitioner.
P. Kalita.
P. Colita.
P. Kalita, the learned counsel appearing for the petition. Raised for adjournment of the matter. Have you intimated the other side?
Yes, there.
Which is not objected by the learned counsel appearing for the.
On
appearing for the
24th, Your
yeah,
Honor.
24 not possible. Let the matter be
26th, Your Honor.
No, let the matter be listed on 10th of September.
10th of September.
10th September.
Obliged.
Your lordship, with the consent of the other side, I'd like to mention item 14, your lordship.
I said
Item 14,
14.
the counsel appearing for this matter is from Delhi, your lordship. That due to some personal difficulties not available to the lordship.
Item number 14, right? Your name?
That's your lordship.
You're appearing for the petitioner. Your name is not there in the. Ms. A. Das appearing on behalf of Mr. H. Agrawal, the learned counsel appearing for the petitioner. You are appearing, the respondent,
Lordship, yes. Respondent number 2.
which is not objected by the counsel, appearing for the respondent number 2.
CDF
Let the matter be listed. When do you want?
Your lordship, short date.
Let the matter be listed on 17 September.
Much obliged.
May it please your lordship. Lordship, with regard to item number 46, your lordship. Lordship, actually, my senior, Mr. K.H. has some difficulty today, your lordship. Is traveling out of station, your lordship, today.
Okay,
Some
on
accommodation
the prayer of Mr. B. Das.
DJ Das, lordship.
Das, the learned counsel appearing on behalf of Mr. K. N. Chaudhary. You have intimated the other side.
Lordship, if my chambermates must have informed, lordship. If not also, then I will inform right now, lordship.
Let
Mr.
the
J.
matter-
Hassan is there,
Let the matter be listed.
Lordship, item 36.
36.
46.
46, not 46.
On 11th of September.
I'm appearing on the other side. For the respondent number 2.
You don't have any objection.
Date may kindly be fixed.
Mrs.
Can it be little bit of early, lordship? It is not inconvenient, lordship.
Not possible.
Not
Laws,
possible.
board is
Understood.
11th.
Lordship.
The only difficulty is that the interim order has rather
Lordship.
become infructuous
Hmm?
because the interim order was passed on 1/8/2025 when the charge sheet was not filed and the no coercive action was directed not to be taken.
You raise
But-
this issue on the next day.
Lordship,
Absolutely.
absolutely. The interim order may be extended till 11th.
Interim order so passed earlier, shall extend, shall be extended.
Both in IA and in.
11th of
11th.
Much
I
obliged.
looked.
Listing of a motion BA matter for tomorrow. Motion BA matter.
We go to the senior bench. Senior bench.
May please your lordship. Lordship 480, the application of lordship. FIR starts from page number 14, your lordship. At this stage, CD may be called for it.
Can I get money, sir? Yes.
Yes, lordship. FIR starts from page number 14, your lordships. At this stage, CD may be called for it.
Okay, heard Mr.
Essay Borgo, your lordship.
S.A. Borgman, the Learned Council appearing for the accused applicant, also heard Mr. B. Sharma and AP for the same. It's an application called for CD. Later material listed one.
8.
8.
Deep level.
Yeah, please, your lordship. Okay, an application for under section 483 of PNS, your lordship. This one was arrested on 1/8/2026 also. In connection with STFPS case number 5 of 2026, and he was since 11/8/2026.
Okay, we'll call for the CD in this case.
All for case there is lordship. Short date to be given. All for case there is short date to be given.
Your name?
GG Gogol.
Mr. G.G. Gogoi.
GG Gogol.
You are not there in the case.
Yes, lordship.
You filed Wakalam now.
Yes, lordship. Case number 3.
Okay, G.G. Heard Mr. G.G. Gogoi, then also heard Mr. B. Sharma. Then this is an application under so and so. Call for the CD. Later material fixed on
9th, lordship.
9th.
No problem.
The case diary may be called for.
Okay, right, as Nawaz B. Sharma, this is an application by proceeding.
Only pray for a shorter date may be possible.
Lordship, 8.
8 will be difficult, there are some matters.
So 7th is possible.
10, 10, 10, 16.
Take your pick.
Charge sheet matter, lordship.
That state case lordship. Behind the work since 65 days lordship.
55 days.
65 days. Already quite got bail, be arrest bail.
What is the space now? What is the space now before the trial court?
On the charge sheet submitted.
If you heard Mr. So-and-so, Learned Council appearing for the issues applicant, also have vision, but this is an application. Then you write call for the PCR in connection with Rathabari.
Already,
Or the PRC has been registered. Huh?
registered.
PRC now, PRC 531/2026 from the Learned Chief Judicial Minister Sri Bhumi Kisan. Let the matter be listed on
14th, lordship.
Not take.
Thought it's kind
Can't
of
be more than so.
important.
Can't be more than this.
10 day, lordship.
Lordship.
Charge sheet matter, lordship.
Charge sheet lordship. Lordship,
Okay,
BA
right.
number 2138 of 2020 is a similar matter arising out of the BA number 2138 of 2026. Vicky Borman is a similar matter. It's fixed on 24.
Same FIR.
Same FIR, lordship.
Fixed on
24/8/2026.
24/8.
Lordship.
Okay, heard Mr. So-and-so, then council. Then Mr. V. Sharma, and APV, it is an application. Then you write, PCR has been called for in that other matter already.
Lordship, TC has been called for this.
Okay, then you write, the Learned Council, for the accused applicant submits that another bail application arising out of the same FIR. That is bail application number.
Bail application number 2138 of 2026.
26. Arising under the same FIR has been listed. Not to be listed on
24/8/2026.
24. Therefore, replace the instant matter. I mean, instant bail application could be also tagged with the aforesaid bail application. Let this matter be listed on 24 along with the other bail application. Okay.
Okay.
Ma'am, please, your lordship. Herein the son and father is before your lordship.
Hmm.
Page 10 is the affair.
Hmm?
Page 10 is the affair. In the affair, whole allegation is against the affair name case number 1. May I read the affair, your lordship?
One second. No? Yes.
Herein the petitioner number, I am referring for accused number 2 and 3, your lordship. But in the affair, only allegation is against the accused number 1. And he has already been arrested, your lordship. And 2 and 3, they are the brother and father of the accused number 1.
Okay, heard Mr. A. M. Khan,
Yeah.
the learned counsel, appearing for the accused applicant. Also heard Mr. B. Sharma, learned LPP for the state. This is an application in the section 482 of the NSS 2023, praying for pre-arrest bail to the accused applicants in connection with Chunari PS case number 5/2026 under section 74/75/127 bracket 2/62/351 bracket 2/296/3 bracket 5 of BNS 2023. An FIR was lodged on 12/7/2026 by one Javed Ali before the officer in charge Unani police station alleging that on 9/17/2026 at about 1 p.m. when his wife went to the field for grazing cattle, the accused number 1, namely Noor Hussain, came from the behind and after closing her mouth, pulled her inside the jute cultivation field and tried to commit some illegal acts on her. It is alleged that after hearing the woman cry, the informant along with one Hasim Ali and Kamal Sheikh went there and rescued his wife from the accused. It is alleged that the accused fled away after the incident, and thereafter when the informant went to the house of the accused number 1, the family members, including the accused number 2, 3, had abused the informant. On the basis of the FIR, next on the basis of the FIR, so this registered PS case number 5/2026. After hearing the respective counsel, the parties is going to consider the opinion, the accused applicants should be granted free arrest bail. Accordingly, it is directed that in the event of arrest of the accused applicants, in connection with Chunari PS case number 5/2026, the accused applicants will be released on furnishing of bail bond of rupees 20,000 each to the series of like nature. Release and PS bail, like nature, subject to the following conditions. That it is 3 conditions: appear before IO, then 10 days, 10 days. Then you other 3 conditions. In terms of the acquisition direction, the instant AV application is disposed of.
All right.
The FIR is at page 14, Your Lordship. I'm a news reporter, Your Lordship, of profession. There was a quarrel between the husband and wife, and the wife reached out to various news reporters of the district, Your Lordship.
You also demanded money, extortion.
No, Lordship.
Then
That is a false case.
1 lakh rupees. Who? You asked for this.
That is a false case, Your Lordship.
Hmm?
The husband, just in order to prevent us from publishing any news, has lost this account. That is the fact, Your Lordship. In fact, I have been instructed that yesterday the co-accused supposed this only is AB 1922.
What? AB?
AB 1922. Your Lordship.
AB 19.
I have a copy of the.
You take it, record his name. Record his name in the same order. Yesterday we have allowed. But we will allow this. The same order will be passed.
Disposed of.
Disposed of. Disposed of. Same.
1922 CD was called with entering, Your Lordship.
Is it?
Yes. And exit is.
Then you write the same order will go. Okay?
18.
No, not disposing in frames.
18.
18.
18.9 is the date.
18.9.
AB 1922.
Okay. 18.9. Same order will go. That will be.
Then I. My lord, hearing this case, my lord, the husband of the petitioner expert in a road accident. He, my lord, road accident, my lord, claiming compensation in respect of death of her husband. My lord, during, my lord, actually.
Where is the FIR?
My lord, FIR case 13, my lord. Case 13, my lord. 11%.
FIR is page 13.
13, my lord.
Who has filed the FIR?
My lord, a complaint has been filed by the Bajaj Alliance General Insurance Company to the CID. CID referred the case, my lord, concerned PS, Boko PS. Boko police station has registered that case. My lord, only. That's up.
This is regarding false claim of insurance money probably looks.
My lord, accident took place on 30th December, my lord. My lord, in the FIR, PM report, medical certificate, police report, police certificate, everything, my lord, on 30th.
What about the injury part?
My lord, injury part as per postmortem, there is some discrepancy, my lord. My lord, you lordship kindly see, my lord, page 34, my lord. For a moment, my lord. Where this is the, my lord, a death certificate issued by the Boko PH, my lord. This certificate has been issued on the basis of the wrong information, my lord, issued by the concerned Gauhati. My lord, here in this certificate, date.
This death certificate is issued by whom?
Issued by the Boko PHC, my lord, on the basis of the, my lord, wrong information. Wrong information means, my lord, if I feel lost, it can be.
Who has gone for this application? There has to be some application for death certificate. Then some information has to be given. Who has given those information?
My lord, this certificate has not been submitted before MSc tribunal. My lord, my submission, my lord, every document for date of death, my lord, on 30th. This is the contravention.
Mr. Sharma, let him go. Let him cooperate.
My lord, I will cooperate, my lord.
What will call for the case, the lodge?
Not if
It may be required, Lordship, because these,
See, I mean, there is maybe some false, I mean, some discrepancies in the date is there.
Yes.
And some discrepancies may be there in the, I mean, injuries.
yes.
I mean, that will, I mean, he'll cooperate.
Yes, Lordship, let him be in interim, Lordship. I am only praying, Lordship, discrepancy might be there. If there is discrepancy, Lordship will allow it. But the fraud part, Lordship will kindly examine
Hmm.
after the perusal of the case diary. Because I have come across several cases, Lordship, where insurance money is claimed based on an accident.
Then now thing is that already this has come to their notice.
Yes.
They have already filed in complaint.
Yes.
So they will obviously, they'll inquire into the matter, investigate the matter.
Yes.
So, I mean, what is the point of
Just
keeping-
to apprise your Lordship, Lordship will kindly see only Lordship will, for Lordship's satisfaction, Lordship will kindly call for the case diary.
Okay, we'll give him some interest.
Yes, in introduction given.
Okay, heard Mr. So and so, one of the learned counsel appearing to the accused applicant also heard Mr. B. Sharma, learned APP for the state. This is an application under section 482 of BNSS 2023, praying for PRS claim to the accused applicant in connection with Boko Police Station case number 67/2006 under section 61 in bracket 2, in bracket small b, stroke 217, stroke 240, stroke 264, stroke 398, bracket 4, stroke 336, bracket 3 of BNS 2023. An FIR was lodged on the basis of the complaint. An FIR was lodged. Which page it was? FIR.
FIR, my lord,
13, page 13.
13, my lord. Yes, 13.
An FIR was lodged on the basis of a complaint by Bajaj Alliance General Insurance Company Limited. Limited. Alleged contrary that the accused applicant's husband who expired in a motor accident has committed a false claim by giving certain false details. On the basis of the aforesaid complaint, police registered Boko Police Station case number 67/2026 under the commencing sections. After considering the materials available as well as the submissions made by the council preparing for the respective parties, the securities of the opinion that some interim protection should be given to the accused applicant, namely Srimati Pobita Das. Accordingly, it is directed that in the event of arrest of Srimati Pobita Das, she shall be released on interim pre-arrest bail on furnishing of bail bond of rupees 20,000 with the security of like nature to the satisfaction of the arresting authority, subject to the following conditions. We give these 3 conditions: 10 days, correct, and then not to temper, then call for the CD, let the matter fixed on
14th.
14th September.
Obliged. 21.
Okay, pass it off.
21, we have received the case diary.
Let's wait for some time.
24.
24, my lord.
24 can be after something.
20.
24.
23.
20,
23.
23, madam.
10%. After 5 minutes.
After some time. To 24, case diary has come.
Case diary not received, my lord.
This second application, madam.
Madam,
Case diary not received.
madam, I have paid for some time to produce the case diary.
Okay, we will give them some time. Mr. D. Bora is present for the accused applicant. Mr. R.J. Burwal, line of AP, submits the case diary is yet to be received. Let the matter be fixed on. When Mr. Burwal?
My lord, this is from Panbazar PS, my lord. On 26, my lord.
Objection.
25 to 20.
I am for 23 minutes, yes, 23, but who has mentioned, I don't know. I'm
You
for-
don't come and just in between, you mention it,
That
you
is
are not
the-
there,
I'm
I
not-
can't
not
help
to
it.
disturb your
I
lordship, but
can't help it.
then after some time then I.
25, 26.
Okay, 23 item number was, he was not there. I mean, that matter has been
Yes.
fixed.
Yes,
That matter, okay, that matter has been fixed. I mean, CD was not available.
yes, serious.
CD was not available, so we have fixed that matter.
First.
Pass on.
27.
CD has come 27?
Case there is not come, my lord.
Hmm?
Case there is not received, my lord. 27.
No, I mean, why CD is not received from Burwa? It's from which
Dhubri PS, my lord.
WPS, so many dates have been given.
My lord.
Tell me what is to be done. I'll call for the, call the inspector, I mean, IO then.
The latest take instruction, my lord.
They get interim and then like CD doesn't come. I mean, what is this?
We'll take instruction, my lord, whether, my lord, where the case there is not received, my lord. Maybe, my lord, search is also perhaps submitted in this case.
Okay, you take it.
I'll also take that instruction. If search has been
Hmm?
submitted. I'll also take that instruction.
Because I mean, interim or protection they get and then they disappear.
My lord.
I mean, CD doesn't come
After some time, my lord, we'll take.
after some time.
After
7, 28. 29.
21.
21, affirmative.
CD has come.
Case there is received, my lord.
Okay.
Start. Earlier, the matter was rejected, lordship. Two petitioners were there. One
It is
was-
this year, no?
No, lordship.
Case there is, my investigation is pending, my lord. Only, my lord, subject to correction, my lord.
Hmm.
The person, he has already completed 60 days, my lord.
Yes.
Whether, my lord,
6 days is complete.
60 days.
today is 62 days, my lord. I have calculated.
Have Mr. M.I. Hussain, the learned counsel, appearing for the case applicant, also have Mr. Arjun Bohra, learned PPT for the state. Is an application under section 482 of BNS. Being for granted bail to the accused of connection to the court for this case number 175/2026 under section 61 in bracket 2 bracket smaller stroke 318 bracket 4 stroke 336 bracket 3 stroke 338 of BNS rate section 66 in bracket C stroke 66 bracket D. Full stop. The learned counsel appearing for when one second. The allegations against the accused applicant. You were the person who was running this, I mean, facility center.
No, lordship.
You
That
were?
is another way, that is one Ismail Hussain and.
And how you were involved?
Actually, that Ismail Hussain and I have some rivalry. Some documents were found in my house. That was
Sir,
something conspiracy. That was, and I have.
How, if you have rivalry, how your document landed up
Yes,
in
yes,
somebody's place?
that is the case,
Well,
lordship.
Huh?
There,
How?
that,
They have planted it.
I have submitted in that way, lordship, and I have filed FIR also, lordship, with the SP in this regard.
My lord, from the case there, my lord, there are sufficient materials, my lord, since, my lord,
he has completed 60 days, so that is why I'm
And
not-
I remember this case was vehemently opposed when the bail was considered. I mean, there was another case that for the.
There are
for-
materials collected, my only matter there is investigation is pending, that is why search could not be submitted.
Okay, right, allegations against the accused applicant is that he is involved in certain cyber crime. The learning council appearing for the accused applicant submits that he has already spent 62 days behind the bars, and therefore he is liable to be released on default bail as the statutory period is of 60 days for the alleged offense. Mr. RJ Borua, learned APP, has also confirmed that 60 days period has already been over. Taking into account the aforesaid, it is directed that the accused applicant shall be released immediately on bail, in furnishing of bail bond of rupees 50,000 with a surety of like nature to the satisfaction of the which court,
CJM, Kamrup.
CGM Kamrup. CGM Kamrup, subject to the condition that the accused applicant shall be cooperative with the investigation and make himself available as and when required by the investigation.
Sorry, Lordship, it's SDJ, Judicial Magistrate First Class Boko, Lordship.
That's what I'm asking. Boko cannot be corrected. No? When these two conditions, then we take in terms of the aforesaid direction, the instant bail application is displayed. Is that has come? 28?
28 has been adjourned. For updation, 28. In the morning, it was
28 mentioned is it? MSA. Doesn't mention.
Article 30.
30 case that is not received, madam, he is on interim. Madam.
Okay, right. So is present for the accused applicant. So RJ Borua and APP service, which case there is yet to be received. Let the matter be listed on when, Mr. Borua?
3-9, madam.
39. Till that, when the interim order so passed on this, I'll continue.
Lordship, report was called for, Lordship.
Case that and status report call for not received, madam.
Lordship, today 4-5 days, Lordship. Lordship, nothing, victim is recovered, Lordship, FIR page, Lordship, 12, Lordship, vernacular, Lordship, kindly say vernacular page 12, Lordship, victim is recovered, Lordship. Lordship, last portion, Lordship, Oriala, Hathor,
From which police station?
Lordship,
This is from my lord,
Bhograpur, please.
Bhograpur, my lord.
Bhograpur, Lordship.
Let it come Monday, my lord. That's all.
5 dates have been given.
Lordship,
Monday, my lord.
Lordship,
5
victim is,
days.
Lordship, victim is recovered. कुछ तो हरिभक्त हमने घुराई दिए हैं.
No. I mean, wait, victim is recovered doesn't mean that we. What was the allegation?
Allegation, Lordship, kidnapping, Lordship, minor daughter. Both are minor, Lordship, lab affairs, Lordship. 18 and 9, 17 and 9, 18.
Produce the case diary on Monday or otherwise tell him
Monday,
to
yeah.
tell him to come
My
himself.
On
Third,
24, my
Mr.
lord.
N.I. Alam,
Yes.
N.I. Alam RK, the learned counsel including for the accused applicant, also heard Mr. RJ Borua, learned PDP for the state. It is seen the case that is yet to be received. Though as many as 5 dates have been given for production of the case diary. Let the matter be fixed on, let the matter be fixed on 24th. 24th August.
24 hours.
24 August. In the event of non-production of the case diary on 24th August, the court will pass appropriate order.
Yes. 32.
Yeah, please, your lordship, city was called for.
Received.
These statements were recorded earlier, lordship was passed with notice twice. That is at annexure 4 and 5.
What is the allegation against you?
Allegation is that lordship one, the plot of land is there of Mrs. Sangeeta Datta.
Where is
So-
this, FIR?
FIR is at page
12.
16, lordship, 12 and 16. Two, one is that complaint and one is FIR. 12 and 16, lordship.
So which is the FIR?
FIR is at 16. Based on page 12, lordship. FIR is at 16, but it is based upon the complaint. That is at page 12, lordship.
Page 17 also.
Thirty-two. Yes.
That's-
Who is this Salim Khan?
Selim Khan is apprehending arrest. Is apprehending arrest.
How you are connected to the land?
That means that electricity connection was taken in his wife's room.
Why? It is somebody else's house.
Yes, lordship, but he was allowed to stay there.
But he was evicted.
He was
Some
allowed.
other person was allowed to stay. He is not the person.
Yes.
So
Yeah,
you have a
that
gang of
person-
doing this. You have a gang of doing this kind of things. He take place on rent, then somebody else will take the place on rent, and he will not pay the rent. Then he will be evicted. Then some other person will come, and siltily he will install his. With the connivance of maybe some officers, you will take up this. What kind of things are this? What is that?
Lordship, very interesting case. Lordship will kindly bear with me. This person, Lordship Salim Khan, he has one case pending against him in Bhangagar PS case 9 of 24, which has already been charge sheeted. Another case, Lordship, is pending against him. That is Lordship Polton Bazar PS case number 344 of 25. And Lordship, he has cases pending against cyber crime fraud, Lordship. That is from Lordship Varanasi, Uttar Pradesh. Cyber case has been lodged against him. His name features in there. This is first Lordship. Secondly, Lordship, he was granted interim. He did not appear before the IO. Second ground is this. He did not appear before the IO, Lordship. That is apparent from the CD.
Yes, lordship. That
Let me
appeared.
finish, Lordship. Lordship,
But what about after this interim order?
he did not appear, Lordship.
Statement was not recorded, Lordship.
Hmm?
He went, but his
No,
statement was not recorded.
Absolutely not, Lordship. Third ground, Lordship, which I'm placing before Lordship. He was, before filing of this AB, Lordship, he was arrested on 11/6/26.
Hmm.
He was in the police station.
Hmm.
He escaped from the police station, Lordship. And Lordship, fourthly, regarding the merits, Lordship, I'm placing, Lordship, the tenant was somebody else. Now, Lordship, the electricity was connection was given to the one Ruby,
Resma something.
for Resmal, his wife.
Mm.
Now, Lordship, when the tenant, the landlord, Lordship, she raised an objection.
Mm.
Then, Lordship, the police found out from the office of the electricity, Lordship,
Mm.
that some documents were submitted.
Mm.
Those documents are, Lordship, one notarized affidavit signed by the landowner, giving her no objection to the new electricity connection. Second is, Lordship, one notarized affidavit signed by Ruby Resma Chaudhary showing herself as the occupier and possessor of that land. And third is one indemnity bond signed by Ruby Resma Chaudhary. Now, Lordship, all these documents are forged. When the wife was examined, Lordship, she in her statement stated, I do not know any person by the name of Sangeeta Datta. I have never stayed there. I don't know which documents are these. This is a statement of his wife.
Both are hands in gloves,
Lordship.
tight hand in gloves.
Yes. And Lordship, only on the ground that he has not appeared before the IO after the interim, that this may be rejected, Lordship.
Okay, heard MS S.C. Ahmed, the learned counsel appearing for the accused applicant. Also heard Mr. B. Sharma, learned APP for the state. The allegation against the accused applicant is that he had he along with his wife procured illegal electricity connection connection occupying the premises of the informant. It is also alleged that it is also alleged that when the informant wanted to give her place to rent to give her a place for a rent to another person, the accused applicant accused applicant threatened the first person of not taking the place on rent. Next paragraph. This a coordinate bench in this code by order number 22/6/2026 has granted interim pre-arrest bail to the accused applicant with a direction to appear before the investigation officer within 1 week. The learned EPP has produced a CD and the same is produced. It is seen that there are several cases pending against the accused applicant, and also seen that the accused applicant after getting the interim pre-arrest bail, did not appear before the investigating officer.
Very colorful minutes.
The learned APP has produced a document which contains details of the criminal antecedents of the accused applicant, which taking into account the entire facts of the case and the prima facie incriminating materials available in the CD, this court is not inclined to grant any relief to the accused applicant. Accordingly, the interim pre-arrest bail granted to the accused applicant by order number 2026 is cancelled. The instant AB application is rejected.
Lordship, in item number 27, Lordship had asked us to take instruction why the CD has not been produced. Lordship, the charge sheet has been submitted.
Okay, 27, who is there, 27?
Yes.
Please be your lordship. May I kindly call my senior?
Who is your senior?
Sir, Surajit Das.
Okay, we'll take it after something.
Lodge.
Okay.
Charge sheet.
এবার কপিতে ঢুকে পারেন আমাদের মিসপ্লেস হয়ে গেছে
Yes.
Item 20, kindly.
কি মানে আছে
Second bill application,
আইটেম নম্বর
20, NDPS,
This is NCB, eh?
NCB.
Who is there for NCB?
My lord, on last two occasions, kindly see the last two orders, my lord. What is happening, my lord? I have served copy twice.
He was not keeping well, Mr. Chaudhary was not keeping well. I don't know what has happened now.
I have seen yesterday him in the court.
You just, huh?
Yesterday I have seen him in the court.
Mr. Chaudhary was
Yes.
there. No, okay, then he call him possibly. We'll wait for something. You see, if his junior is there, you can call.
25, 26.
May it please your lordship. In this case, and what.
CD has come?
Also, after few minutes, Lordship, our Guru has gone to the first minute.
Declare. May it please my lordship. If your fire statement has been recorded after lordship protection.
CD has not been received, Lordship. He is on interim, Lordship.
Because CD not received interim order. To continue, let a matter be listed on
14th, Lordship.
14th.
If the blessed.
34.
May it please your lordship. Anticipating bail application, the petitioner was granted interim protection, madam. Here the petitioner has appeared.
Lordship, yes, it is. Some monetary dispute is there, Lordship.
Okay, heard Mr. S. Numbers, the learned counsel appearing for the opinion, also heard Mr. V. Sharma, the people for the state. This is an application under section 4 of the VNSS. VNSS, aiming for anticipatory bail to the accused applicant in connection with Malbury PS case number 82/2026 raised under section 126 stroke 117 stroke 296 stroke 3 stroke 303 stroke 351 3 at VNS 2023. The allegations against the accused applicant is that it's right, like the allegations against the accused applicant, the applicant is regarding certain loan and non-payment, certain loan from the informant and non-payment of the same. Loan was taken by whom?
Was taken by the
The
complainant.
informant,
Informant.
yeah. Then what happened?
He took the loan, he
Hmm.
issued a check,
Hmm.
he issued multiple checks. As
Hmm.
per the FIR, the allegation is that he took the loan,
Hmm.
he issued a check, but on the way, I, along with other people, had intercepted him,
And then
taken away his vehicle.
vehicle and
Taken away his vehicle and beaten him up, my lord. But our case is that, my lord, he had taken 10 lakhs, issued checks, we deposited the checks got bounced. We issued a demand notice or issued a legal notice to the informant, my lord. The vehicle, as per our instruction, he had placed the vehicle. That has already been given to him.
Hmm?
The vehicle has already been given in Denmark.
Vehicle has been recovered and given to the informant.
Right, right. What is written? Last line? No, no. Education against the accused applicant is that the informant had borrowed some money and the accused applicant and due to some the accused applicant and in lieu of issuance of some seats, however, the accused applicant had taken away the vehicle of the informant, which has already been granted Jima to the informant. The learned counsel appealing for the accused applicant submits that in terms of the interim order dated 24/7/2026, the applicant has already appeared before the investigating officer and his statement has already been recorded. He submits that he is cooperating with the investigation and shall cooperate with the investigation, and therefore his custodial detention may not be required in the instant case. And Mr. B. Sharma, the APP has confirmed that the accused applicant has appeared before the investigating officer and the statement has been recorded. Taking into account that proceed 5 is qualities of the considered opinion that the prayer for a civil application of the accused applicant should be granted. Accordingly, the interim PRS bill order dated 24/7/2026 is made absolute and the instant AV application is disposed of.
35. Page also. FR is at page 30 also.
Is there is come?
Yes, sir.
The vernacular page 30.
Hmm?
Page 30 is the FR also. Vernacular page. May read it all. Doctor.
You are in interim.
The lordship only petition number 4 is on interim lordship. At page 34, lordship will find that the person, lordship, the husband of the informant, at page 34, lordship, lordship has gone to the FIR.
This is page 34.
Yes, page 34, lordship, the village lordship had issued a certificate because on that, if lordship pleases lordship, on the day of LS incident lordship.
No, where is the FIR?
FIR is at page 30 lordship.
Let's go to the FIR.
Yes,
Let's understand what is there.
May I read this lordship?
1 second, let me read. Okay. 4 has been given interim.
Yes, only petition number 4.
He is the father of.
Petition number 2.
Yes.
Yes, the actual fact is, lordship, on that particular day, lordship, at the house of the petition number 3, lordship, there is a birthday party of his minor daughter, and all his relatives and guests came. After they left, lordship, at around after 2 a.m., the husband of the informant, by breaking the glass of his house, entered his house with an intention to commit theft. Thereafter, they have apprehended and they informed the local persons. Then also local persons have arrived and all of them apprehended the husband of the informant and they informed the police. Subsequently, police came and police took the husband of the informant.
Or what happened to his hair?
Lordship, that To my submission, upon inquiry, I came to know, Lordship, few days, 2 days earlier, the alleged incident, Lordship, one, he had met with an accident. Perhaps CD might have that I not.
How can you lose hair when
Lordship,
when there is an accident?
Lordship, the petitioner has not committed to that action.
No, I'm asking like what happened to his hair? You are saying that he met with an accident and he lost his hair.
No, after met with the accident, he does not lose his hair.
Then how he lost his hair?
Lordship, the village persons apprehended him. And
Apprehended him, that's what I'm asking you, how he lost his hair. The allegation is that he was tied in the electric post and thereafter his hair was, I mean, shaved by, by these accused applicants.
And Lordship, the FIR is lost after 4 days, Lordship. So that is, we are not aware how, but the local
Yes,
persons
Mr.
and Lordship, kindly,
What is it?
kindly,
Simple
Lordship,
injury, Lordship, medical, as per
Hmm?
medical, as per medical report, simple injury with blunt force.
Simple injuries.
and Lordship, kindly produce page 34 for a moment, Lordship.
What is that?
The certificate issued by the village person, Lordship.
What kind of certificate?
There is a Lordship village meeting held on that particular early hours of that after the incident, Lordship. And police came in to take away the husband of the informant, Lordship. I am ready to cooperate with the investigation.
Okay,
I
now
will
Mr.
submit all the
now
documents.
Mr. S.M. Krishna K. The learned counsel appearing for the accused applicant, also Ms. S.H. Bora, by an APP for the state. This is an application under section 482 of BNSS 2023, claim for pre-arrest bail to the accused applicants in connection with Secretary Police Station case number 55/2026, corresponding to GR case number 27729/2026, registered under section 61 bracket 2, 127 bracket 2, 117 bracket 2, and 1182 of BNS 2023. An FIR was lodged on 26/2026 by the informant, namely Gilimani Daka, before and the officer in charge of Secretary Police Station alleging entirely that the accused persons named in the FIR called her husband to their home for celebrating a birthday party on 19/6/2026 at around 11 p.m. It is alleged that when the accused when the husband of the informant was not returning home, the informant along with her mother-in-law went to the place of the accused applicants and saw that the accused applicants were beating her husband, being tied up in an electric post. Tied up with an electric post, tied up on an electric post. On receipt of the FIR, police registered a Secretary Police Station case numbers 55/2026. Learned counsel appearing for the accused applicant submits that, in fact, submits that on 19/6/2026, there was a birthday party at the minor girl of the accused applicant number 3.
Yes, the
Okay.
2 and 3 and 4, same also.
No, minor daughter of whom?
The 3, petition number 3.
Minor
Paragraph
daughter-
7 also.
minor daughter of the accused applicant number 3. When the party was over, the accused applicant noticed that the accused applicant noticed that the husband of the informant, namely Ajay Dekkan,
Orup Dekal also.
Arup Dekka, entered their residence by breaking a glass panel with the intention of committing theft. On apprehension, after seeing that the accused applicants had apprehended him and handed him over to the police post. This admits that the accused applicants have not committed any offense as alleged in the FIR, and the FIR has been and false story has been narrated in the FIR. It further submits that the village body of the concerned village has also issued a certificate some certificate stating the facts that the accused that the husband of the informant had in fact gone to the place of the accused applicants for still imposed. In view of the aforesaid, it admits that the accused applicants should be granted 3 years bail. The CD in the instant case has been received and the same is perused. Same is perused after taking into account the entire facts of the case and the materials available in the CD. This court is of the considered opinion that the accused applicants should be granted anticipatory bail at this anticipatory bail. Accordingly, it is directed that in the event of arrest of accused applicant number 1, 2, and 3. 1, 2, and 3. The 1, 2, and 3. This will be released on furnishing of bail bond of rupees 20,000 each with the severity of like nature to the satisfaction of the arresting authority, subject to the conditions that accused number 1 to 3 shall appear before the investigating officer within a period of 10 days. The accused applicant shall cooperate with the investigation and make themselves available as and when confirmed. Then next paragraph, as regards accused applicant number 4, who has already been granted convention 2 years bail by a coordinate bench of this court, white order dated 28/7/2026. The interim the aforesaid interim 3 years bail orders is made absolute. In view of the aforesaid directions, in terms of the aforesaid directions, the instant review application is disposed of.
Deeply over.
The report was sought for whether any case has been registered against a petitioner. That report is awaited.
Yes,
That is awaited. That is awaited. Also.
Okay, right. Mr. Ganguly is the learned counsel is present for the accused applicant. MS SH submits that the report is still available. The report regarding yes, right. What is that report?
Lordship.
No, report was called for whether any case is pending.
The report regarding whether any case is registered against the accused applicant is still awaited. Post
He's a bank manager.
later matter will be listed when
Lordship, can it be on 28?
28. Let the matter be listed on 28. I feel that 28. If my entry of the show passed all this, I'll continue to the listed.
Okay.
Yeah.
38. Map this also 482 application CD was called for motion. CD received.
City Lordship, yes.
Lordship, FIR in case 7, Lordship, translated type technique, allegation of rape and stalking is there, Lordship. There was a consensual relationship, Lordship. In example, two, Lordship, I have next some photographs, Lordship. Page 11 to page 16, Lordship. Lordship, that the girl is major and after broken up of their relationship, when the relationship gets over, Lordship, she filed.
Yes, madam, what is there?
My lordship, victim statement is there.
Hmm.
And so far as her statement is there under section 183 and 181 BNS's lordship. But the person put her under threat that if she, lordship, the story is in nutshell is this. May,
After 10 days of the alleged incident, she
complainant-
filed the FIR, Lordship. After broken up of their relationship.
Hmm?
After broken up of their relationship, Lordship, after 10 days, Lordship, she filed the FIR.
While the victim went with the accused in the car, he had shown her some naked photos of the victim and thereby threatened her to comply with the demands that he has made to her lordship. Accordingly, she has been taken to a hotel room where he has made physical relationship with the victim against her will, lordship. So on that pretext of he has threatened her to kill her mother if she discloses the fact in front of others, lordship.
Is major, Lordship,
There is no denial on that part. There is no,
there was a consensual relationship was there.
that is admitted, the lordship. Prior to the occurrence, she has been shown some naked photos of her and thereby make her to give her consent, lordship.
Is
Threaten
that
her, lordship.
false allegation?
If she doesn't
Totally false allegation, Lordship.
comply with his demand, then he will disclose the entire facts before the public, lordship. Her statement also supported by the statement of the wife of the accused, lordship. Kindly go through the statement of the wife. Admittedly, the accused is known to the victim, lordship.
Hmm?
She is known to the victim, lordship. There is nothing dispute.
There is something, but like, where is the, where,
Lordship,
from
kindly,
where you are saying that they had relationship?
lordship, kindly go through the 183 statement
No,
of
I
the
read-
victim.
reading it.
Yes. It is there, lordship.
Lordship,
But they were in a love relationship, from where you are saying so?
That is not there, lordship.
Lordship, may kindly paros my annexer to page 11, Lordship.
What is that?
Lordship, I have annexed some photographs of that hotel, Lordship.
A
Which
photograph, maybe there are photographs of friends together.
no,
Does it mean
Lordship.
that have some relationship?
Lordship, that shows, Lordship. If Lordship kindly
I've
paros
seen that,
the
I've seen that,
photographs,
I've
Lordship,
seen that.
they were in a consensual relationship. After that, Lordship, when broke out, after broken up, Lordship, she filed this as a.
So after broken up, okay, fine. You had a relationship, there was a consensual relationship, everything is fine.
Lordship.
But after breaking up, after your relation has been broken up, then are you supposed to like make those videos public?
No,
Yes,
Lordship,
lordship.
that is not done, Lordship.
Lordship,
That is done,
That is
That
not
is-
done.
that is
not-
done as per the CD. That is done.
That
That
is
is done.
not
You
done.
have, you have made viral.
And lordship,
Not
kindly go
lordship.
through the statement of the wife of the accused, lordship. That is very relevant.
When my wife came to the.
Is a married person
to
having
the-
children, lordship?
Lordship, when my wife came.
How
to
many
the-
relationship you have? A wife, you have another girlfriend, ex-girlfriend, you have another more girlfriends. How many girlfriends you have?
No, Lordship.
No?
Lordship, my humble submission is that custodial detention may not be required for further investigation, Lordship.
and you are a married man. And still you keep on chasing females. Hmm? And you are saying that like you are innocent, you are nobody.
I'm not saying innocent, Lordship. The rape and these two sections, rape and stalking, does not affect me, Lordship. That was consensual, Lordship.
That investigation will have Mr. J.S. Ahmed, the learned counsel appearing for the accused applicant, also have Mr. S.H. Bora, learned appearing for the state. There is an application under section 482 of BNSS 2023 paying for anticipatory bail to the accused applicant in connection with Dalgaon Police Station case number 116-2026 under section 351(2) stroke 64(1) stroke 78 of BNS. An FIR has been lodged. An FIR was lodged on 18-2026 before the officer in charge, Dalgaon Police Station, by the informant alleging entirely that while she was waiting for a bus, the accused applicant came with a car and asked her whether she should be asked her whether she would like to be dropped in her place. When the informant went inside the vehicle, and after proceeding for some time, the accused applicant showed the informant certain photographs and videos in his mobile phone, wherein she could see that the accused applicant had stealthily taken certain naked photographs and nude videos of the informant. The accused applicant thereafter threatened her that if she doesn't consent for having some physical relation with the accused applicant, then the videos and the photographs will be made public. And on such treatment, the accused the informant consented to the physical relation with the accused applicant, and they had a physical relationship in a hotel. On the basis of the FIR, the police registered Dalgaon PS case number 116-2026. The learned counsel appearing for the accused applicant, Dalgaon Police Station under the aforementioned sections. The learned counsel appearing for the accused applicant submits that the accused applicant has been framed by the informant. He submits that the informant and the accused applicant had consensual sex, and there is no possible physical relationship with the informant. He further submits that no videos or photographs have been made viral or public by the accused applicant. He submits that the accused applicant is willing to cooperate with the investigation and therefore custodial detention is not required. On the other hand, Ms. S.H. Bora, the learned APP, opposes the prayer for anticipatory bail application of the accused applicant, stating that there are sufficient incriminating materials against the accused applicant. CD in the instant case has been produced and the same is produced in consideration of the submissions made by the counsel appealing to the respective parties and on perusal of the materials available in the case diary. This case, this court is not inclined to grant any relief to the accused applicant. Accordingly, the instant AV application is disposed of. CD to be returned.
Obliged.
Here, Lordship, CD was called for that we have not received, and IO has made a prayer for further.
CD not received. Let the matter be listed on
Lordship, can it be on 7th?
7th. This is regarding what? NDPS?
Anticipatory bail, Lordship?
Anticipatory bill.
Anticipatory bail for what? What was the allegation?
Section 486 BNSS under.
No, allegations against you?
64,
Allegations against you?
Under section 64(1), Lordship.
Okay.
64 clause 1.
You will wait for the CD, okay? We'll wait for the CD. When
7th of September.
7th September. Later matter fixing 7th.
Obviously.
He was called for the CD.
CD has come.
41 Lordship, CD has not come, Lordship.
But the requesting for an interim protection, Lordship. At least with the woman, Lordship. The 40 Lordship. Because entire family in the.
It's the anticipatory bill. He's
Yes,
behind the bar, Lordship. Kindly give us a date so that we can produce the case.
So at least the woman, Lordship. It's number 2, Sufia Begum.
So, Mr. S.K. Poddar is present for the accused applicant. MS SH Bora Lanet APP submits that the CD in the instant case is yet to be received. Let the matter be listed on, give a sort of
Lordship, on 7th.
Lordship, next week, Lordship.
7th. Next week,
Too long, Lordship.
7th.
next week not possible.
Maybe on 29th.
Anticipatory
27th.
bill,
Okay, second will do. Put it on 2nd of September.
Lordship.
Kindly
Second of September.
Production to the at least the woman.
Women are more dangerous than this.
This case relates to, my lord, whether finding of the charge sheet, my lord,
Hmm.
whether I have to appear before the court for a limited period, my lord. Which generally the court passes an order that you appear before the
No,
trial.
see, court passes an order if so advised.
If so advised.
So it's up to you. I mean, the court that doesn't direct
Yes, my lord.
that you go and appear. But like if you say that like some liberty should be given, then if court thinks that since interim is granted, so court thinks that like okay, we can extend it for certain time. If you are advised to appear there, you can appear, or otherwise, if charge sheet is filed, the court is at liberty to cancel the interim protection.
Interim.
So interim protection is extended on the basis of the material.
Fine.
So if somebody says that like let me give some liberty to go there and appear, then let me give. Yes, yeah. So facts are like that.
Fine. My lord, this case, my lord. Asfaq, Mohammed Asfaq,
Yes.
my lord. My
Yes.
lordship may kindly have a look at, my lord, paragraph 5, my lord.
Para 5.
Para 5, my lord. Cognizance was taken on 1/10/2022 by the Sessions Court.
Hmm.
The Sessions Court noted in this order that on 8/8/22, the High Court had protected the appellant with the interim order directing that he may not be arrested. When the application was heard by the High Court next on 18/1/25, without adverting the pending anticipatory bail was rejected, and the High Court went on to direct the appellant to surrender before the competent court and seek regular bail.
Okay, let us read this line again.
My lord,
When the application was heard, first is like interim was granted.
yes, madam.
High Court protected the appellant with the interim order directing that he may not be arrested. Correct?
Right.
Then now, when the application was heard by the High Court on 18/1/2023, without adverting, the pending anticipatory bail was rejected.
And
The High Court went on to direct the appellant to surrender before the court. So this is not happening in this kind of in our court.
Madam,
At least this.
my submission will be, my lord, in our court, my lord, generally says, my lord, your anticipatory bail is extended for the 15 days. It's up to you whether you appear before the trial. So it is a moreover a kind of a, my lord, surrender, because if I go there in a magistrate court, my lord, and if the case is of, my lord, Sessions Tribunal. So in the instant case, my lord, it is, my lord, attempt to murder, it is a trialable by the Sessions Judge, my lord. So the magistrate court, my lord, allow my prayer or may not allow. So there is every possibility, my lord, it may dismiss my regular bail application, which will be filed there, my lord. On the ground, my lord, that the case will be trialable by the session judge. That is one aspect, my lord.
So that is why now, see, charge sheet is filed against somebody means what? Charge sheet is filed against somebody means there are materials against the accused person
Yes.
for a trial, right?
Right.
So on the basis of this, what the court can do is that interim protection that has been given, interim protection you have been given,
Yes.
then court will consider the case on the basis of the CD along with the charge sheet maybe.
Right.
Then on the basis of this, the court will decide whether the interim protection should be extended or not.
Not.
So court is at liberty to cancel cancel your interim protection at that moment only.
Right.
And then you are at liberty whatever you want to do.
Right.
But in certain cases, what happens? I mean, the court sees that okay, interim protection has been granted after hearing the counsel.
Right.
And now now the charge sheet has been filed. That means there are incriminating materials. But since the interim protection has been given, some more protection is given so that he can go and like appear if he is advised. So I mean, in that order, what is wrong in?
My lord, if that is some extension is given, my lord, then I appear before the magistrate court.
Then extension will not be given to you. That's all. We'll
But-
cancel the bail order.
The lordship will cancel the bail on perusing the record. My lord.
Correct, perusing the record.
But
Perusing the record means the charge sheet is filed. So a charge sheet is filed means there are incriminating materials
My lord,
against you, certain materials
that
against
matter
you.
with my all respect, my lord, that I do not agree, my lord. Because if a lordship, after charge sheet also, persons come before the court for anticipatory bail.
Yes.
And in that case, generally the court calls for the record of the case, my lord.
Correct.
And upon perusing of the case record, if it finds, my lord, although charge sheet is late, my lord, bail is granted, my lord. There
It
is one
depends.
aspect.
It depends.
Depends.
It depends.
My lord, in this case, my lord, paragraph 15, my lord. 5 I have already read out, my lord. 15, my lord.
Then you read 5 to about 5 again.
My lord. Cognizance was taken on 1/10/2022 by the Sessions Court. The Sessions Court noted in this order that on 8/8/22, the High Court had protected the appellant with the interim order directing that he may not be arrested. When the application was heard by the High Court next on 18/1/23, without adverting, the pending anticipatory bail was rejected. And the High Court
So bail was rejected.
rejected.
Bail was rejected. And
Yeah.
High Court went on to direct the appellant to surrender. So fact practically different.
My lord, but our case will be, it's a more or less, my lord, surrender before the magistrate court.
No, it's not surrender. If somebody is advised, if you are, I mean, this is from the council, it comes that like liberty should be given to appear. So in that case, the direction is passed
Right.
that like, okay, this since the interim was granted, we'll extend it for some time. If you are advised, you go and appear.
Right.
That is what.
Yeah,
But
now-
here the case was different. Here the anticipatory bail was rejected, and
Rejected.
after that, the High Court directed him to appear.
Right.
I mean, that is a direction given. We
Right.
do not pass this kind of order.
Now, your lordship, may kindly have a look at paragraph 15. my lord.
15.
One
yes.
side, my lord. What appears from the record is that the appellant cooperated with the investigation both before 8/8/22, when no protection was granted to him, and after 8/8/2022, when he enjoyed the protection, till filing of the charge sheet and the cognizance thereof on 1/10/22. Thus, once the charge sheet was filed and there was no impediment, at least on the part of the accused, the court having regard to the nature of the offense, the allegation and the maximum sentence of the offense, they are likely to carry or to have granted the bail as a matter of course. However, the court did not do so, but mechanically rejected and virtually to rub salt in the wound, directed the appellant to surrender and seek regular bail before the trial court. Therefore, in the opinion of this court, the High Court fell into error in adopting such a casual approach. Next paragraph, paragraph 16, my lord. The impugn order of rejecting the bail and directing the appellant to surrender and later seek bail, therefore cannot stand and is hereby set aside. my lord.
So we don't pass this order, Mr. Datta. We don't ask them to surrender. We do not ask them to surrender. We say that like, if so advised, we always put if so advised. I mean that too on the basis of the prayer made by the accused applicant.
Well,
No, not on
Yes,
on
my
the
lord.
on volume.
Generally, our court gives a direction, my lord. Your anticipatory bail is extended for 15 days. you may appear before the trial. So it is more, if when I appear, my lord, the court will put me behind the bars. So there is an apprehension, always, my lord. So it is moreover, my lord, my understanding, my lord, is a kind of a surrender.
I don't think that, I mean, we do not ask them to, we
That's
do
my
not ask them
submission,
to
my lord.
surrender.
That's my submission, my lord. Your lordship will kindly look it. Now, another case, my lord, it's my lordship may kindly have a note it, my lord. Criminal appeal number 830 of 2026.
Criminal appeal number?
Criminal appeal number 830 of 2026.
Criminal appeal number?
830 of 2026. Arising out of, my lord, SLP criminal number 1536 of 26, my lord.
1536
36
of
of
26.
2026, my lord. No, no, I'm sorry, my lord. I had only one copy, my lord. My lord, I'll provide this copy, my lord. Just I have to read. My lord, here the paragraph, my lord. Paragraph 11, my lord. Kindly note, my lord.
Yeah, there are 11.
Paragraph 11. A plain reading of the order referred to above would indicate that an anticipatory bail was granted by the High Court as prayed for, but the same was limited only up to filing of the charge sheet. Once the charge sheet was filed, the protection earlier granted comes to an end, and in such circumstances, the appellant once again prayed for anticipatory bail by way of a fresh application, which came to be rejected by the High Court. So now, my lord, if your lordship, my lord, grants me bail, my lord, for 15 days, I appear there. I filed a regular bail application out there, and subsequently it was rejected. Then there is an option, my lord, different option, my lord. One option is that I may again approach this court, my lord, by way of filing an anticipatory bail.
After a regular bail is rejected?
Yes, my lord. Regular.
No, not regular bail. I mean, after your appearance and rejection by that court.
By the court. So there is every possibility that I have to come to the court, my lord. Now, this is paragraph 11, my lord. 13, my lord. Earlier, the court may grant anticipatory bail or may decline. However, once having exercised its discretion in favor of the accused upon consideration of the overall matter, there was no court reason for the High Court to restrict it upon the stage of filing of the charge sheet. This is, my lord, paragraph 13. Paragraph 15, my lord. If the aforesaid be so, then the High Court should have indicated, while declining to grant anticipatory bail by way of the impugned order, as to what was so particular or what was so gross that the High Court thought fit not to grant anticipatory bail. Well, here in this case, well, the Sushila Agarwal's case has been discussed, my lord. Paragraph 18, my lord, kindly note, my lord. In Sushila Agarwala and others versus State of Delhi, my lord, the following questions were referred to the larger bench of 5 bench. Number 1, my lord, whether the protection granted to a person under section 438 CRPC should be limited to a fixed period so as to enable the person to surrender before the trial court or seek regular bail. This is question number 1. And in this question, my lord, the court answered, my lord, this court held that the protection granted to a person under section 438 CRPC should not invariably be limited to a fixed period. It should ensure in favor of the accused without any restriction on time. This is number 1. Second question was, which was put, whether the life of an anticipatory bail. What is the life of an anticipatory bail? Whether the life of an anticipatory bail should end at the time and stage when the accused is summoned by the court. It answered, my lord, as regard the second question referred to this court, it is held that the life or duration of the anticipatory bail order does not end normally at the time and stage when the accused is summoned by the court or where charges are framed, but can continue till the end of the trial. I am providing this, my lord. And my lord, our coordinate bench also, my lord. In 2 cases, my lord, I have found, my lord, where the order is of like this, my lord. The petitioner was granted interim bail on 31/26. It is submitted by the learned additional PP that in the meantime, upon completion of the investigation, charge sheet has been submitted by so and so. In view of the above, the interim bail dated so and so granted by the court is made absolute subject to the condition, my lord.
Okay,
One more order of another coordinate question. So my respectful submission before your lordship is that, my lord, once your lordship has granted me increased protection, my lord, whether after the filing of the charge sheet, my lord, if I appear before the trial court, my lord, not trial court, my lord, before the committal court, my lord, the magistrate court, which is, my lord, the section which are there, my lord, are trialable by a sessions court, my lord. So there is an every apprehension that I may be put behind the bars.
but you have been given an opportunity.
That's why, my lord,
Apprehension is there.
apprehension is there, my lord,
Defined.
because the magistrate court say, my lord, it is trialable by the sessions court, my lord. Now, my respectful submission is that, my lord, once bail is granted, my lord, interim bail, my lord, it should continue till end of the trial. That's my submission, my lord, lordship will consider it.
Okay, Mr. Borga.
Yes, madam. Madam, my learned friend has already relied on Sushila Agarwal, madam. This is a 5 judge bench, my lord. And it is very much clear, my lord, that anticipatory bail may be extended, my lord, even, my lord, till end of the trial also, my lord. But, my lord, facts and circumstances has to be looked into, my lord. Under what section he has been booked, my lord, or what is his role, my lord, during investigation, my lord. Now, let's say for a time being, my lord, lordship will peruse, my lord, section 480 of the BNSS, my lord. BNSS from the sir.
BNSS.
BNSS.
SS.
SS.
Yes.
No, my lord, when bail may be taken in case of non-bailable offence, my lord. When any person accused of or suspected of
No,
of
482.
commission of
You are
480, my lord.
480.
80, my lord.
Hmm.
When any person accused of or suspected of the commission of any non-bailable offence is arrested or detained without warrant by an officer in charge of the police station or appears, my lord, or is brought before a court other than the High Court or Session Court, he may be released on bail, but such person shall not be released if there appears reasonable grounds for believing that he has been guilty of an offence punishable with death or imprisonment for life, my lord. If he is, my lord, surceased, my lord, which is, my lord, punishable is, my lord, death or imprisonment for life, my lord, then only, my lord, the my lord, committal court cannot, my lord, grant bail, my lord. Otherwise, my lord, normally, my lord, when High Court protects him, my lord,
Discretion is there.
discretion is there, my lord. Now, my lord, regarding, my lord, Sushila Agarwal case, my lord, that my lord, learned senior friend has already, my lord, point out, my lord. Bail can be, my lord, anticipatory bail can be extended, my lord.
So there are another condition provided that when the committal court cannot grant.
Bail only on the offences.
Number two, you see,
Yes,
such person shall not be released if such offence is cognizable offence and he had been previously convicted
yes, my lord.
of an offence punishable with death, imprisonment for life,
For
or
7 years.
imprisonment of 7 years or more. He had been previously convicted on 2 or more occasions of a cognizable offence, punishable with imprisonment of 3 years or more than less. So 3 years also. So
Yes,
3 years also, if somebody is convicted for 3 years twice,
yes, my lord.
then also it can be rejected. That
Rejected,
is
my lord.
statutorily provided.
Rejected.
But
Yes.
otherwise, in other cases, there is a discretion.
There is a discussion, my lord.
There is a
But
discussion.
trial court will see, my lord. What is the, my lord, incident of the, my lord, this accused petitioner, my lord?
And it doesn't say anything about whether it's a committal court or it's a court that is going to be, going to try the case. Doesn't say so.
My case is, my lord, I'm not, it's subject to correction to my friend. I'm not referring to trial court. I'm referring to the committal
But
court.
committal-
the
That is, my
provincial
lord,
court, my lord.
appears before the court,
That was
other than
saying
high court or
which
court of.
It doesn't define which court.
That
That
is
means the
specific, my lord.
committal court is also inclusive.
Yes, my lord. My lord, that is specific 480, my lord. Brought before a court other than high court or session, my lord. That means, my lord, obviously, my lord, trial court or the committal court, my lord. If trial court.
That includes committal court. That's what.
Yes, my lord, that is. And secondly, my lord, there are also other decisions, my lord, that is 2003 8 SCC 77, my lord. Bharat Chaudhary versus another versus State of Bihar, my lord.
What does it say?
My lord, it is also, my lord, same as regards, my lord, what Sushila Agarwal has, my lord, stated, my lord. That anticipatory bill, my lord.
Sushila Agarwal, I mean, give me the reference, Sushila.
But
Yes,
it's
but-
already there, madam.
Is
In
there?
Sumit's case, it's there,
Uh,
madam.
uh.
Paragraph, I think, my lord, 13 or 15, madam. Sumit,
No,
Sumit.
Sushila Agarwal case, my lord, paragraph 91.1 and 91.2, my lord. These are the relevant paragraphs of Sushila Agarwal.
Referred.
So my humble submission, my lord, this accused petitioner, my lord, at present, my lord, he is the custody of this honorable court, my lord, because he has been given, my lord, PRS bail, my lord. So Lord Siemens, my lord, let him appear, my lord, and his interim protection may be extended till his appearance, my lord. And let him file, my lord, application for regular bail, my lord. And I am not submitting on merit, my lord, because the scan copy of the case that he has come, my lord. So, my lord, I have also flagged mark regarding the merit, my lord. The merit, my lord, there are sufficient materials are collected by the
Is that is already available?
scan copy, yes, my lord.
Scan copy is
Yes.
available. Charge sheet is available.
Charge sheet is filed, man. I send. And in Sushila Gowda, my lord, only one sentence is important, my lord. Again, if there are any special or peculiar features necessitating the court to limit the tenure of anticipatory bail, it is open for it to do so, my lord. If, my lord, there are some materials, my lord, then, my lord, it is open for the court to do so, my lord. That line is very important, my lord, in Sushila Gowda case. And, my lord, the similar, my lord, view also taken in, my lord, Satyendra Kumar Antil versus CBI, my lord. That is 2021 10 SCC 773, my lord. Relevant paragraphs are paragraph 3 and 5, my lord. Paragraph 3 may be, my lord, Peruk, my lord. Until it is, my lord.
What does it say, para 3?
That the forwarding of the accused along with the search warrant had not necessary when the accused was not arrested during investigation and he cooperated throughout in the investigation, including appearing before the investigating officer whenever called for, my lord. So, my lord, it does not, my lord, require that, my lord, when the search is filed, my lord, the accused is required to be taken into custody. And paragraph 5, my lord, it is specifically mentioned, my lord, where the accused not cooperated with the investigation, my lord, and not appears before the IO, my lord, then when Where further investigation, including the possible recovery is needed, the accused is not entitled to the benefits money. That is para 5.
These two cases, the coordinate base, they have given this on the, I mean, on the factual premises.
Well, one case, I think.
Factual premises available.
No, madam, one case, madam.
Both on the factual premises. Though charge sheet has been filed,
Yes, madam.
but on the basis of factual premises.
And my lord, my learned friend is very much fair, my lord. While making his submission, he said, my lord, the role of the accused petitioner should be considered during the period of investigation. After my lord, I have been protected, my lord. I appeared before the IO.
That is one of the considerations.
Yes, my lord, I have fully cooperated with the IO. Please leave with your lordship. If your lordship is not satisfied, then one amicus may be also be appointed if your lordship pleases.
No, not required. Not required, we'll pass an order.
I am obliged.
Right. Had Mr. N.J. Becker's Learned Counsel, appearing for the accused applicant, which about Mr. L.J. Becker, Learned AP for the state. We'll pass the order. Order will be passed to on a later date.
It will be disposed of money.
Today, I don't know. I mean, we'll have to check it.
I am obliged.
If possible, we'll do it.
Only matter we have to write down in our petition whether it is
Not
pending or
that,
disposed.
let's see. I mean,
That is
I cannot assure you.
my lord.
Okay.
Lordship, I'm sorry, inadvertently it was shown as passed over. So inadvertently the matter was shown as passed over, so I had left. Now, there was some wrong notice in the mention. Actually, 28 was passed over. Okay. So, before your lordship takes up the matter, I would just like to place one thing before your lordship. I am required to file my objections, which my clerk had passed over to the petitioner's clerk. Ultimately, it was returned back and the petitioner's counsel had told that he is no longer in the case. If my friend accepts the objections, it is all right. But he cannot say he's appearing, and when it was served, he says, I'm not appearing in the matter.
Lord, I'm totally unaware of all these things.
It was served, then it was again cancelled, lordship. Let him accept it today, lordship will take up the matter
But
tomorrow.
why these things are created, I don't have.
No, he's saying a serious thing.
My lord, very serious allegation, so I seriously objecting, very serious allegation.
No, so
Very
he's saying,
unfortunate, my lord, everything is false, my lord.
he's saying that what disposed?
False, my lord. Not
False.
correct.
False. Now he's saying
I'm
that.
waiting this morning when your lordship is saying.
I'm not into that. He's saying that he has prepared an objection.
Right.
It was given to your client, I mean, to your clerk, and your clerk has refused to accept it.
No, it was refused at first, then it was again returned back. But he is no longer appearing in that case.
It was accepted first.
It was accepted first. The signature is also there. Now I put some weight.
My lord,
There is no clerk I have there.
Then who has taken it?
My lord, in the morning, one Jibon, my lord, told me that such a copy has came. He is not my clerk. Sometimes he used to have. He told me, yes, some copy was.
Anyway, lordship, he can accept it now. Lordship will take it up tomorrow.
Yes, man, why not? I can. But why these all things are kept, I don't know, man.
No, that is something
I am
because it
waiting-
is
I am
on
waiting for
record.
early discussion.
Maybe some miscommunication.
No,
But
sure.
you agree to take it, you take it, and we'll take it up some other date. When do you want? You tell us. Both of you tell us.
Why did I not receive it, my lord?
Well,
Whatever, now some miscommunication. I don't know. I mean that I don't know. I can't say comment on it.
Exactly, my lord. All the allegations from such a
I
part of my
cannot.
lord, I
comment.
don't.
No, he's not making allegation against you. He's saying that like your clerk has accepted it, then it was returned.
I am not no more appearing. How it can be, my lord?
anyway, lordship, I'll serve him a copy right now. Lordship may take it up tomorrow or Monday, anytime at his convenience, lordship.
Okay. Okay, on the joint prayer of the council appearing for the parties, let the matter be fixed on Monday. We'll take it up on 20.
Lordship.
Let the matter be fixed on 24th. A copy, please submit.
Yes, right now.
My lord, Monday, my lord, that is 24th, my lord, maybe on 25th.
Okay, 25th.
Shall I not receive it? Yes.
Okay, 25th we'll take.
Lordship.
25 and 26.
Wait, please, your lordship. Both the matters connected with the same FIR and we were under interim protection. We have appeared before. the
It has come.
My lord, we have received the case there, my lord. So I have also, my lord, contacted the IO, my lord, regarding, my lord, the indecision of this accused person, my lord. He said, my lord, the accused person has not appeared before him, my lord.
Okay.
That is why, my lord,
File an affidavit.
Interim was granted.
interim was granted, my
But
lord,
it
on
did not appear.
their statement I have not found in the case there, my lord. That is why, my lord, I have verified from the IO, my lord.
Hmm.
So he said that they have not appeared, my lord.
File an affidavit in that case, your lordship. We have appeared before the IO, your lordship, in both the cases, your lordship.
So let them cooperate, my lord, then. Let them cooperate till the investigation is completed.
What was the allegation?
Your lordship, the allegation is that it's in page number 9. At night hours, some people threw stones at them in the eve of New Year's Eve, your lordship. That is in the month of January, your lordship. Simple injury to the extent, but here.
Okay, let him go.
Let him cooperate, my lord.
Heard Mr. P. Laskov, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Burwa, learned appearing for the state. This is an application under section 483 of BNSS 2023. Praying for pre-arrest bail to the accused applicant in connection with Longpa PS case number 03/2026, registered under sections 61 in bracket 2, stroke 126 bracket 2, stroke 310 bracket 2, stroke 351 bracket 3 of BNS 2023. The case arose out of the FIR dated 4/1/2026, roused by one Mahmoudul San with the allegations that on 2/1/2026, he and his friends were returning home in a four-wheeler bearing number AS01FA 7844 and subsequently, near Nilbagan, the accused signaled their vehicle to stop, alleging that an accident had taken place and as they did not stop, the accused chased them in another four-wheeler having registration number AS01DH6966 along with a motorcycle and thereafter blocked their way and assaulted them. Later on, they ran away upon seeing a police vehicle. A coordinate bench of this court by order rated 28/1/2026 has granted interim pre-arrest bail to the accused applicant. Full stop. The learned counsel appearing for the accused applicant submits that in terms of the aforesaid direction, in terms of the aforesaid order dated 28/1/2026, the accused applicant has cooperated with the investigation. But there was no time limit given to him for appearance in this case. No time was fixed. Cooperate with the investigation and appear before the IO. Nikhil Vyas. He has appeared before the investigating officer. And he have given your statements. And he given your statements? And he has given his statements. Full stop. The letter APP. The CD in the instant case has been received and the same is perused on perusal of the CD as well as on consideration of the submissions made by the land council obtained for the parties. This court is of the considered opinion that that the interim period is bail order dated 28/1/2026 should be made absolute. Accordingly, the instant AB application is disposed of by making the interim pre-arrest bail order dated 28/1/2026 absolute. Full stop. The other one is same.
Same affair, same allegations.
Same, no? Only same thing. Same interim, same,
Deeply affected.
both are disposed of.
27.
Madam, 27 charges submitted, madam.
Charge sheet submitted,
Interim is-
huh?
interim is-
Interim is there. We heard Mr. S. Das Lalane Council, if any accused applicant, also heard MS. I also heard Mr. Ajay Burwal on the APE for the state. It is an application under section 482 of BNSS 2023. Paying for granting anticipatory to the applicant in connection with
Section 305.
in connection with Dubri PS case number 38/2026, registered under sections 305/331 of the of BNS. The learned APP submits the charge sheet in the instant case has already been filed. In view of the appropriate submission, the learned counsel appearing for the accused applicant submits that liberty should be granted to him for his appearance, and then liberty should be granted to him to approach the jurisdiction court for appropriate relief. Full stop. A coordinate bench of this court by order dated 16/3/2026 has granted interim pre-arrest bail to the accused applicant. Full stop. Taking into view, therefore, this court is under considered opinion. Taking into account the aforesaid, the instant AV application is disposed of with liberty to the accused applicant to approach the jurisdictional court if so advised. If so advised, full stop. If so advised. Till his appearance before the before the jurisdiction court. No. Under earlier line, you write within 15 days, right? Appear. Within 15 days, till his appearance before the trial court. And before the jurisdictional court, within 15 days, the interim pre-arrest bail order within 16/3/2026 stands extended.
Highly affected.
Lordship, parcel number to लिख लो मुझे.
Oh, nice.
CS number 113/2026, dated 22/4/2026.
Please look, while this application, my lord, petitioner challenge, my lord, the order dated 18/1/25.
You have not filed any objection,
No, my lord, because I have oral,
but you have earlier paid for filing objection.
I intimate the matter to my client, but
Hmm?
he did not, I intimate the matter to my client,
Hmm.
but she did not turn up because due to because her husband died, she alone in her house, she unable to come. That is why.
So you are not filing any objection.
No.
So well, kindly see my lord page 19.
178.
My lord, cross of PW1. Let us respond number 1.
Yes, ma'am.
Page 19.
PCR was also not called for.
No.
Hmm? PCR is not required.
My lord, here, my lord, my lord, the order was passed, my lord, violating the established law, my lord, of this. Kindly see, my lord, law.
No, don't come to the law straight away. Give me the facts. You give
Yes,
me the
that is-
facts. You
that
give
is
me the
page-
give me the
page-
things.
page
Then you come
19.
and I'm just asking whether TCR will be required or not. If TCR is not required, it's perfectly
Lordship.
fine. But if you say that
But see,
TCR is
NI
required,
case, your lordship.
huh?
This case is under for NI negotiable instrument act, your lordship.
Mm.
My sake has been, they have, my lord sake in, for repayment against the money which has been lent by him. And my lord, that sake is bounced. I have filed properly due time the case. Notice was sent to him, but he did not reply. Then, my lord, I have filed the case. In the meantime, during pendency of the case, my husband died. So being widow, very trouble to face financial, my lord. And this till today also, my lord, I did not get anything, your lordship. That is why it disposed of, my lord.
Yes.
Page 19, my lord.
Mm.
Cross of, my lord, PW1. Let
You
us-
give me the facts first. What happened in the case? How the case is proceeded?
My lord, on complainant, my lord, the complainant Abdul Ali filed a complaint case, my lord, alleging offense under section 138 of NI Act, my lord, against the present petitioner, alleging dishonor of check of, my lord, rupees 2,60,000. The complainant, after receipt of the said check, deposited aforesaid check in his SBI account, my lord, Nalbari branch, but said check was returned unpaid.
Mm.
With return memo by banker of the accused petitioner with remarks insufficient. Thereafter, my lord, the case was instituted.
Then
My lord, evidence was given, my lord, kindly see evidence of PW1. The important point, my lord, page 19, cross of the PW. That is very important.
where is the statement?
My lord, page 19.
This is cross or a statement?
Oh, yes.
Hmm? Page 19 is what?
My lord, page 19 is cross of PW1. But
And
it's
what,
stated in paragraph
no,
4.
what about the statement? Where is the statement?
Paragraph 4, man. Page 7, man. In her cross PW1, send this email. So paragraph,
Where is her statements?
at paragraph 4, man, of my
Paragraph 4 what?
statement, man.
Before the trial court.
Oh, yes, that
Where is that?
that is not here.
That is not the only you have given the this thing. Prosecuting part. How it will be heard now? Yes, what?
Page
say?
25, man.
Hmm.
Page 25.
What is that?
That is, man, cross of PW1.
25.
Yes,
Vernacular.
And
Vernacular.
this is the 19 is translation part.
yes, man. That's fairly similar at 11th line, man, page 19. Money was given for 10%.
One second. What is the after his death I do? I know the name of the accused. I forgot the name. Salary of my husband was
30,000
30,000. It is true that my husband lent the money for business benefit.
benefit.
Hmm. I have mentioned the name in the evidence of affidavit. It is not a fact that I have given false statement. I know accused came for money as friend. On one reason my husband lent received money to the accused, paid at home. In time of giving the money, my daughter and Rafiqul were present. They have not submitted affidavit. I have submitted the check with my affidavit. So what do you want to show?
Well, the 11th line, money was given for 10% interest. My lord. And the last line, my lord.
Hmm.
Money was given for 10% interest.
Hmm.
And last line, kind
Why did you issue the check then?
Yes, my lord. My husband served as Chowkidar of PWD Mechanical Division.
Hmm.
He was a government servant. For the port.
Now, why you have given the check then? Why have you issued the check? If it is for 10% interest, then why have you issued the check?
My lord, as
No,
per
see,
provision
if
of
you-
law, my lord,
if-
kindly see the provision of law, my lord. The Assam Civil Services Conduct Rule 1956, 65. As per my lord, Rule 10, 4B, my lord, sub rule 4B. No government servant shall serve in ordinary course of business with a bank or firm of standing duly authorized to conduct banking business, either himself or through any member of his family or any other person acting on his behalf. Lend money to any person at interest or in a manner whereby return in money or in kind is charged or paid.
Okay, you file a complaint against him in the department. His service will be terminated. He's already expired.
Already expired.
Ah, so-
At that particular point of time,
No,
he was
no,
government
whether,
servant.
whether you have filed any complaint against him, you have taken the money, you have issued the check. Now you are taking the ground that he is a government servant. He should not. He's not allowed to. He's not allowed to give any money back.
This is law, my lord.
This is law. So you go to the department. You file a complaint there. His service should be terminated. And how it is relevant here? This is a check you have given. Your check is bounced. As simple as that. What kind of plea you are taking? Now the person has died. Now you are saying he's a government servant. He is not allowed to give money on land. He cannot give money on loan and on the for interest. So you have already taken it, availed it. Now he has died. Now you are not returning the money. You have issued a check. The check is bounced, and you are saying that like he's a government servant. No?
That
What kind
stand
of
was
plea you are
taken
taking?
at the, my lord, at trial stage, that stand was taken in the court.
Now you take the stand in trial stage. What has happened in the trial stage? What the court said? What court said? What court said? Let us see where the court considered this your this thing, your plea. Where is that?
At page 48, may I kindly see your lordship, para 11. Para 11 of Roman 2, wherein it is stated that in this case as complainant, Oli Begum as PW1
One
deposed
second,
in
one second. Page
48, your lordship.
48,
48.
para
It
2.
does mean, yes, para 2. Oli Begum as PW1 deposed in her evidence
No,
on
no,
affidavit that her late husband Abul Ali had instituted case on complaints case under 38 Act of Iman against the accused protestant before the CGM court Nalbari. During pendency of the said case, her husband expired. PW1 deposed that out of friendly relation and urgent financial need, the accused borrowed case amount of rupees 2,60,000.
No, I'm asking like he has taken a plea that he has taken that plea before the learned trial court, and where the learned trial court has considered that. I just wanted to see how he has what is his consideration. Yes, Mr.
My lord, I may be allowed some time, my lord.
No time.
The
no
next
time.
day I'll satisfy lord.
No, no,
lord
no, no, there is no
regarding
time.
this point, my lord.
No, no, there is no time. You show me where he has considered it. You have said that the trial court, it has been, the plea has been taken before the trial court.
Yes,
So
yes,
you
yes.
show me where it has been considered.
In cross also suggestion was not made that he had illegal business.
Sometime may be granted me.
My
Otherwise,
lord, I made,
today I'm not ready for that particular point.
my lord, one submission, my lord.
Today you are not ready, then where you have started arguing? You wanted to show a lot of law to this court. This law, this law. And where is your law now? So we are not going to grant you any this thing, adjournment. Your ground is only that like he's a government servant and like he shouldn't have lent you the money. That is your ground.
No, my lord.
And this is prohibited by
No,
this
my lord.
service law. Huh?
Some grounds are there, my lord.
Hmm?
My lord, page, my lord.
No, no,
9, my lord, please.
that's what I'm asking now, that
Page 9.
where, in which page the court has considered that? Your ground, that ground.
My lord, grounds are here, my lord. Some ground.
The ground of that law you have shown me, no?
Yes.
Your Assam service rules.
Yes.
That where is that has been considered?
That has not been, my lord.
That aspect has been considered by court that you have said. So where is that? Where is that in the judgment? Yes, what are your other grounds?
My lord, to bring home to the charge of section 138 of NI Act, the validity period of check should be 180 days. Not thereafter, my lord. But my lord, in the instant case, my lord, the money was given, my lord, on 1/10/17, my lord. That means check was handed over on that day. 1/10. But the case was, my lord, instituted on thereafter, my lord, in the month of March, after 8 months. That is second ground.
You don't prepare the case and come to argue the case, and you start arguing, wasting court's time.
My lord, since some provision only for that provision, my lord, there's a
You should have mentioned the matter that I am not prepared, that I give me some time, something like that.
My lord, I have simple submission, your lordship. At page 7, wrongly, my lord, they have misguided the honorable court that they have written that husband of PW1, paragraph 4, at page 7, on 1/10/2017, meaning thereby check was issued on 1/10/2017. Whereas on 1/10/17, husband of this complainant, my lord, give the money. And issued, check was issued, your lordship, on 13/8/18.
But since the payment was made on
That was-
1/10/17,
Yes.
thereby, my lord, that check was.
He refused to give the money. Then, my lord, on some request, he issued the check on 13/8/18. The case was filed in proper statutory period following guideline under section 130 of NI Act. So my humble submission, my lord, the case may be dismissed and he may be directed to pay money to me, my lord. Otherwise, they have.
Clear, my lord. Lord,
No, my
From
lord.
in the very beginning,
least-
yes, my
I
lord,
asked.
50%, my
Heard
lord.
Mr. R.S.
He
Sohan,
may
the
be
learned
directed
counsel
to pay.
appearing for the petitioner, also heard your name,
F. Begum,
F. Begum.
lordship.
F. Begum, the learned counsel appearing for the respondent. Hearing concluded, judgment reserved.
Lordship.
Obliged.
Admission.
This petition of this. Quashing of order of cognizance.
Yes. Yes.
Would husband and wife before your lordship, my lord?
Hmm?
Would husband and wife, my lord?
Huh?
Husband and wife, my lord?
Yes, yes.
It is FIR of 2010, man, filed by the father-in-law, man.
Hmm?
Father-in-law has filed the FIR
Hmm.
in the year 2010, man, 5th of February.
2010?
Man, 5th of February, enacted.
Hmm.
It says that her daughter, my lord, kidnapped by the petitioner, my lord, and they could not be traced out, my lord.
Hmm.
And then was on basis of the FIR, my case was registered, my lord, under section Authorised PS case number 366 of IPC, my lord. Then thereafter, she was then the victim was she was also appeared before the police station, and it was found that she was formally married off to the petitioner, my lord, but number one, my lord. That your lords will find that
She was married up to whom?
to this petition number 2 married to petition number 1.
Ah,
That is page annexure 1, page 18, medical, as per a forwarding letter. The Ms. Jyoti Kumari Chaudhary, the elop both which Sunil has the January, they had known since childhood. That page 18 annexure 2, 2 days after they eloped, their family called back, family married off to Sunil. Now they are married, stays at Ujan Bazar at so and so. And case has been filed prior to their marriage, and she has brought for medical leave. So they have settled down, 2 children were born, out of their wedlock. And now, after, I think they are, now charge sheet has been filed in the year 2021, after 10 years, under section 376. So since the matter has been settled already, the informant and the father-in-law has been, notice has been issued, my lord. They have appeared also.
Yes, I'm appearing on behalf of respondent number 2, lordships, and I'm the informant, Your Honor. We have filed our objection on 24 to 2026. We have no any objection if this,
you
at the
don't have
time,
any objection.
yes, at the time of loading of the FIR, yes, Your lordships, I was under the impression that the petitioner number 1 kidnapped the petitioner number 2, lordships. Subsequently, I come to learn that they have a love affair between the petitioner number 1 and petitioner number 2, lordships. And subsequently, they have married, lordships. And at
You
that
have
time,
anything to say?
and at that time, lordship, she was more than 18 years, lordships.
Around 19.
Oh, man.
Around 19 years at the time of incident, my lord.
Incident. I have 19 years.
That medical certificate of the school certificate issued by the
Page number, Your lordships. 34. 38, lordships.
Informant is called before this code.
informant, is yes.
Yes, lordships. And the informant.
Informant is the father.
Father of the petitioner number 2.
Mm. And the petition has been filed jointly.
Jointly by them.
Fine.
So we'll allow this.
Yes, sir.
Right, how Mr. P. Pataki, the learned counsel, senior counsel, assisted by so and so for the petition, for the petitioners. Also heard Mr. P. Dutta, the learned counsel, appearing for the informant, and MS SH Bora, the learned APB for the state. Hearing concluded, judgment is I'll pass the order.
Always.
May I please the lordship? Lordship, we are yet to receive the copy of the memo of appeal. Leave was allowed. And
TCR has come, TCR.
only the lead petition.
It's a criminal appeal. TCR is not called for.
I think it was not called for.
TCR will be required.
Lordship.
Criminal appeal. Okay, right. We'll call for the TCR. Okay, we'll call for the TCR.
Directed to serve the copy.
We'll serve the copy.
We served the copy also. Heard Mr. A. Sakya, the learned counsel, appearing for the appellant. Also heard Mr. P. Das, the learned counsel, for the respondent number 2, as well as Ms. S.H. Bora, learned KPP for the state. Registry to call for the TCR in TCR. From which court? You filed against which court judgment? Registry to call for the TCR.
Yes, these are right.
TCR from the court of the additional district and session judge number 5, Kamrup Metro. Then the learned counsel for the appellant to serve a copy of the memo appeal to the council appearing for respondent number 2. Let the matter be listed after 3 weeks. After 3 weeks.
May it please the lordship, my lord. Hello, this is the quashing application, my lord. And we have challenged the FIR Proceed and we will cognize its order. FIR is at page 71. My lord, that FIR. Otherwise, I have also annexed.
You are from whom?
Lordship, I have a submission to make, Lordship. Lordship, previously, Additional Advocate General P.N. Goswami has entered his memorandum of appearance, Lordship. But then we have recently discovered that they have also engaged their own counsel. So we would not like to,
The PN Goswami appeared for whom?
for respondent number 2, Lordship.
For department.
For department.
Because my lord, memo has been filed, flag is there, my lord. There is no signature of the my lord informant, respondent number 2. And already the respondent number 2 has engaged another state of advocate.
My lord,
In
I am
June.
appear for respondent.
So we will not be appearing, Lordship. That's the submission that he wanted me to
Fine.
make.
So Goswami will not be appearing.
No,
Yes.
Your name has been shown in the cause list.
Lordship, yes.
Okay. You are appearing.
Yes.
Are you filing any objection?
No, lordship, I am only the informant, lordship, and I have forwarded the preliminary inquiry report to the.
The informant is who the informant?
Informant is
Department.
the my lord. Yes.
Department.
Under secretary to the board of. In official capacity, I have filed this affair, lordship,
Hmm.
and this preliminary inquiry report has been.
And Mr. Kotoke is appeared for?
Yes.
For the, as a master,
Huh?
for the chief minister's vigilance element, CM vigilance. That's number 1.
My lord, here, my lord, I have prepared one list of dates.
Hmm.
I may be allowed to furnish to your lordship
Yes.
along with a copy to the my lord opposite councils, my lord.
Hmm.
In your logo, it will kindly do also. It will. My lord, if lordship kindly come
So
to
you,
the FIR.
yeah, you are basically, you have come for washing of the FIR,
FIR, search it and the cognizance order, subsequent order.
charge sheet and cognizance.
Yes. But it is primarily on the ground, my lord. FIR is the forwarding of the inquiry report in the departmental inquiry, my lord. Page 71. That inquiry report was forwarded for investigation. And on the basis of the my lord, inquiry report, lordship, inquiry report, my lord, that
No, let us see the first FIR, what were the
Correct.
regulations?
71, my lord. With may I read something?
Yes, page
reference-
71.
Decease of dated, my lord, 2/5/25.
Hmm.
With reference to the above, I am directed to request you kindly to register a regular case against so-and-so after seeing the then executive engineer, PH in Nalbari Division, and presently posted as Superintendent Engineer PH Halagandi on reinstatement as per preliminary inquiry report submitted dated 28/4/2022.
No, page 71.
Page 71.
हाँ, ठीक है, ठीक है.
Yes.
Yes, preliminary inquiry report
Preliminary report
submitted.
submitted 28.
Copy enclosed.
Yes.
Hmm.
By the then Deputy Commissioner Nalbari regarding misappropriation of government money by Avtar Singh, the then Executive Engineer Nalbari Division, in the form of payment of false bills for construction of IHHL under individual household latrine method under SBMZ. So based on the fact finding inquiry report dated 21/2/2023. My lord, on the basis of this inquiry report, lordship find at page 82.
Inquiry report is page 82.
82, my lord. And 82, it starts like this, my lord.
Okay, 82.
Introduction, my lord, first para, my lord.
Yes.
83.
Hmm.
This said period is, my lord, to the 2022, my lord.
2000.
22 to 23.
And
Now, my
23.
lord, this
Okay.
inquiry report finding conclusion is that, my lord, in the departmental inquiry, that he is involved, therefore, on the basis of the departmental inquiry, my lord, which has been forwarded through an FIR, that has been, my lord, placed before the authority and the authority
Hmm.
impose punishment of dismissal from service, matlab page 41.
On the basis of this inquiry,
Yes.
inquiry report,
Impose punishment, my lord.
imposed punishment,
Yes.
page 41.
Lords. My lord, last para, kindly see, my lord. Now, in the light of the above facts and in excess of power conferred under Article 311(2) of the Constitution of India, Governor Assam pleased to impose penalty of dismissal from service, which shall ordinarily be disqualified for future employment.
So this one you have you challenged?
I have challenged this, and on a challenge before this honorable court, this is the judgment, my lord, page 43.
Page 43.
The judgment is of dated 27 to 25, lord. The honorable court has interfered with the order of punishment, and my lord, page 53, lordship, para 17. The department has been given liberty to initiate fresh inquiry within a period of 6 months.
So that inquiry was set aside.
Yes,
Earlier
earlier
inquiry
inquiry
is
had gone, my lord.
set aside, and like the FIR has been lost on the basis of the earlier inquiry.
Earlier inquiry.
Okay.
And they have, my lord, initiated, my lord, fresh, thereafter, my lord, let me place, my lord. I have been reinstated in service, my lord.
Okay.
Page 54.
54 reinstatement. Okay.
Reinstatement.
You have been reinstated immediately after
Immediate,
after this judgment.
Yes, my lord, 24/4/25, after 2 months, my lord. My lord, after reinstatement, my lord, without going for a fresh inquiry, my lord, on the basis of the judgment of 27/2, they lost the FIR on 2/5/25.
They lost an FIR.
Yes, on the basis of the materials which have been interfered by the honorable court directing, go for fresh inquiry within 6 months. They have initiated the inquiry, my lord, fresh inquiry on 23/5/25. Prior to that, in violation of the order of the judgment of this honorable court, they have instituted the proceeding, my lord. For a check period of 2022-23, after, my lord, 2-3 years gap, my lord, without explanation, my lord, if I could have understood, if they lost the FIR immediately, then and there, my lord, while they discovered that, then it's another thing. My lord, here is a case after interference by the honorable court and after granting liberty to go for fresh inquiry. In between, they have lost the FIR on, my lord, 2/5/25.
Where is that?
Page 71 is the FIR, my lord. On the basis of the materials of the inquiry report, which were directed for, my lord, fresh inquiry. Page 71.
No, page 71, one is the subsequent FIR.
Is the FIR, but this is the FIR, only FIR, my lord.
No, this is-
Initially, they have not lost any FIR.
No. I mean, you said that an FIR was filed on the basis of the inquiry report.
And this is the, my lord, FIR, because this FIR 71, my lord, they have forwarded the inquiry reports only of the departmental inquiry.
Inquiry report on 25/2025 and judgment was passed. Then what did you challenge earlier?
My lord, I challenge the inquiry report and the, my lord, termination order based on the
Inquiry report which was forwarded with this FIR.
Yes.
So you have challenged the inquiry
Yes.
report. The inquiry report was set aside.
Set
And
aside.
they have been.
My lord, said
Order of permission challenge.
order of termination set aside and directed them for go for fresh inquiry.
Go for a fresh inquiry.
In my humble submission, therefore, my lord, the material based on which the FIR loss, having been, my lord, directed for fresh inquiry, this material does not exist on the date of issuance, lodging of the FIR on 2/5/25, my lord.
No, now tell me one thing, like if one inquiry is there, on
Yes.
the basis of that inquiry, there are some decision has been taken by the department.
My lord,
Department has taken a decision that you should be terminated.
my lord,
No, you have been terminated, you have challenged that.
my lord.
Then court has come to a conclusion that that your termination is not correct.
Correct.
So you should be reinstated. Correct.
And go for
So-
fresh.
Go for a fresh inquiry.
My lord.
Now, whether the direction of the court to go for a fresh inquiry deletes all the materials which were available available beforehand in the inquiry report.
Yes, Malad, that is absolutely, that is my ground. Because the initiation of the charge in the departmental inquiry, based on which the inquiry report has been issued and punishment order has been imposed. The charge in the criminal case and the department is absolutely same. Origin is from the same charge that you have defalcated the government fund by issuing some bills. Since this is same having been directed for fresh inquiry, at the time of lodging and more particularly before that, they pursuant to the order of the Honorable Court on 27/2/2025, they in compliance with it, they have directed for fresh inquiry after lodging the affair on 23/5/25, page 56.
Page 56.
Yes. Page 56, my lord. After reinstatement, they have issued the fresh inquiry.
The fresh inquiry in terms of the judgment. Page 50, 56.
Page 57, last part is the date, 23/5/25, my lord.
So this is subsequent to, this is in terms of the judgment.
Judgment. So in my humble submission.
Where is it? Page 50?
56, my lord.
56.
Annex 9, my lord. This is of dated 23/5/25. Without getting, while partially complying with the judgment, without getting a fresh inquiry report, why you have, what is the urgent need to go for the lodging the FIR?
No.
They have put the bulls before the cart, my lord. And moreover, my submission.
Put the cart before the horse.
That's absolutely. Because had they not initiated, that's another thing. They have violated. They have issued a fresh inquiry after lodging of the FIR. That is bad in law. Because, my lord, if certain thing is to be done in a particular manner, in compliance, so far here in this case is concerned, whether compliance of the order is there or not, my lord, judgment 27/2. And my lord, if initial action in lodging the affair is not in consonance with the, my lord, order of the court, my lord, in my humble submission, all subsequent actions shall be rendered illegal, my lord.
Because when the judgment was delivered at that point of time, FIR was not there.
Not there.
They choose not to file an FIR at that point of time. But now they have chosen to file the FIR.
File the FIR, that too before initiation of the fresh inquiry. Your conduct initiates on the fresh inquiry. That means you accept that the earlier report is bad. Otherwise, you could have very well challenged the earlier judgment. You have not challenged the earlier judgment whereby directed for fresh inquiry. You have complied with the judgment giving fresh inquiry 23/5. And prior to that, how you have lost the affair?
Is there any bar that if a departmental proceeding is started, inquiry, then FIR cannot be filed?
In a particular case, my lord, if the initiation of the departmental
these are two independent proceedings, right? These are two independent proceedings. One is the FIR, police will do some investigation because the informant thinks that there are some criminal aspect issues involved there. And departmental proceeding is something like which is internal. Because there are certain allegations, they want to find out whether you have committed some offense or not. Or whether there is some misconduct under the prevailing, whatever the service rules. There is a thing. There are two aspects. Now your ground is that since the High Court has directed for fresh inquiry, so FIR could not have been lodged on the basis of the inquiry which has not been set aside, but which on the basis of which you are terminated, that has been set aside.
And directed for fresh inquiry. Now, my lord, malicious aspect I have brought into this as a ground, my lord. Page 55 is the seniority list of my cadre. As in, my lord, superintendent engineer for promotion to the post of additional chief engineer. There I am at the top, my lord, page 55. My lord, that lodging of the FIR on, my lord, 25, that is actuated by this, my lord. This is the, my lord, seniority list of the cadre of superintendent engineer of 6525. By hook or crook, they want that I should not be, my lord, promoted.
Who?
My lord, the petitioner number 1, my lord.
No. Who doesn't want you
This
to
department, my lord.
to be promoted?
This
Is there
department.
any specific allegation against somebody that somebody wants to uproot you?
My
Or
lord,
like
I have taken it down, my lord. My lord, so far to bring the malicious aspect.
The
Page 55,
malicious aspect against whom? There has to be one particular person or two particular person, three particular person.
my lord, in fact, here in the, my lord, under secretary, my lord, who lost the affair. Number one, my lord, Gupta Singh is,
He is not your competitor.
my lord. My lord, there is a cartel to oust me because such allegation was there from 2023. In between, your service was terminated. However, from the order of the Honorable Court, you have been reinstated. Since therefore, you should not be my lord, promoted to the post of additional chief engineer. And this is because kindly say the chronology, my lord. FIR is of 25 and this seniority list of my lord 65. And for that, I never been promoted to the post of my lord additional chief engineer. Now, my lord, so for lordship's query is concerned from the judgment, if I can, my lord, satisfy your lordship. Kindly take those. Sorry, you can move. In 1996 case, my lord, 1996 9 SCC, but PS Rajya, my lord. There,
1996.
9 SCC, my lord.
Yes, which paragraph?
Paragraph 17, 18 and 19, my lord.
17, 18 and 19.
Yes.
It is on which ratio?
Correct. Here, my lord, the facts lordship will find para.
No, what is the ratio on this?
Yes, ratio is that, my lord. My lord, here also cognizance was taken without, my lord, complying the judgment of the Honorable High Court. My lord, their timeline was given to complete the inquiry within a particular period, 8 months. That has not been complied with, my lord, and therefore the entire and my lord, there is a order from the Honorable High Court stating that to get a preliminary inquiry report first.
No,
Without get-
no, Mr. Das, and
Yes.
tell me one thing.
Yes.
I mean, this case is like which ground, for which ground? You are taking support of this case.
Not complying with the, my lord, order passed by the High Court. In this particular case, there was a direction for getting a preliminary inquiry first, then to proceed. There also they
No,
proceed.
they
without-
asked for a fresh inquiry. The High Court said have first fresh inquiry.
No, in this case, my lord, in the Rajya case, my lord, PS Rajya case, there, my lord, while setting aside the, my lord, earlier FIR, the court said go for a preliminary inquiry first. Without going for a the process taken, my lord, further, and that was challenged. And there the Honorable Supreme Court, page 23, my lord, para 23 kindly, my lord, directly, my lord.
There are 23 also.
Case 23.
17, 18, 19, 23.
Yes. Let me read, my lord, 17, my lord.
No, okay. 23, what is that?
Yes.
Even though
Even though all these facts, including report of Chief Regional Commissioner, were brought into the notice of the High Court, unfortunately, the High Court took a view that the issues raised had to be gone into the final proceeding, and the report of the Central Vigilance Commission exonerating the appellant of the same charges in the deportation proceeding would not conclude the criminal case against the appellant. We have already held that for the reason given on the particular facts of this case, the criminal proceeding initiated against the appellant cannot be pursued. Therefore, we do not agree with the view taken by the High Court as stated above. These are the reasons for our order dated so and so for allowing the appellant quashing the impugn criminal proceedings and giving consequential relief. My lord, absolutely the same case, my lord. In the earlier proceeding, my lord, on the basis of the inquiry report that has been interfered in the present case in our my lord, case in hand, my lord. And therefore, all the proceeding was, my lord, set aside.
জানপেনটো আপুনি টেক্সটো পোৱা নাই ন?
তাকে আছে।
This case may, I mean.
It is regarding valuation report, my lord.
Huh?
There was two valuation report.
The facts will be naturally, my lord, a bit different, my lord. What is, my lord, is the ratio?
Out there, there was a finding that has been, finding that has
Yes.
been arrived.
Yes.
That because, I mean, the departmental proceedings and finding of the departmental proceeding,
Right,
departmental proceeding,
correct,
that two valuations were there, three valuations, whatever.
yes.
I mean, so on that basis, the affair, I mean, the criminal cases also cannot go.
Cannot go, that is
No,
the.
in the facts, same these things, but in your case, it's different.
My case is slightly different on the ground that, my lord, without going for getting a fresh inquiry report.
No, your case, the investigation,
From that-
police investigation hasn't started.
Yes.
The police investigation, I mean, at that point of time, I'm talking about. Now the police investigation has started, the charge sheet has been filed, whatever. I mean, that's a different thing, but at that point, nothing has started.
Nothing.
Hmm.
Now, only after interference, they have now suddenly
No, that is why,
risen
that is why the issues are a little bit different. Anyways, you go.
a bit different, my lord. And, my lord, so for 2011-14 SCC 770.
No, let us finish the facts first.
My lord,
Let us finish the factual part first. Then what happened?
of this matter, my lord.
Your case, your case.
Yes. My lord, so far, the investigation they have collected, the materials.
Now, let us see the charge sheet.
Yes. Charges is based, my lord, 100, my lord. 100, my lord. I have given the, my lord, a certificate copy of this charge sheet. Only allegation is that, my lord, that I force the assistant engineer to issue certain, my lord, completion certificate of work order in respect of certain, my lord, NGO. Only allegation that, my lord, I forced.
Force means what? Conspiracy?
They say-
Connivance?
And So far the force is concerned, there is no explanation. Because those are the officers who has issued the, my lord, work order, completion certificate. And if I really force them, they have not lost any complaint before the higher authority. I'm the executive engineer at the time, chief engineer was there, secretary was there, they have not lost. And so far the money is concerned, my lord, para 16.12, my lord.
Mm.
16.12, my lord. Fifth line, my lord, wherein it is revealed that the said witness was pressurized by executive engineer so and so to put his comment without verifying the field status. That too after making the payment just to regularize the issue verification of the observations attached with the bills, and repeatedly insisted him to put his signature repeat, so he was not willing to do it. What the willing to do it, not willing to on my force, if I pressure you to issue some certificate, then had they, my lord, any investigation authority, my lord, got any report or the complaint from those persons whom I pressurize, complaining that so and so has pressurized to the higher official, my lord. No such, my lord, evidences before the investigating officer. He could not collect, my lord. So far 16.3 is concerned, that money, because here is a project, my lord, the district development officer, DC, is the, my lord, chairman of the committee. There are 3 committees. That committee I have also, my lord, placed. Lordship kindly see how this works function, my lord. Page
Who approves
30.
the bill? Who approves the bills?
This is the, my lord, deputy commissioner. He is the chairman. And
No, no,
While-
bills are approved by the committee or work is being monitored by the committee.
what there is a committee, monitoring committee, my lord. This block water sanitation committee, my lord. Page 32.
Hmm.
There I am not the member secretary. I am the member secretary of the district. And my chairperson is the deputy commissioner. Page 31, my lord. Until and unless there is, my lord, work order issued by the, my lord, Anshalik Panchayat, member secretary Anshalik Panchayat, he is the, my lord, BDO. BDO issue.
No, correct. Now see, like,
And now, my lord,
now
yes,
you are challenging the FIR.
yes. On merit also, there is nothing against me, my
You are
lord.
challenging the FIR, you are challenging the charge sheet.
Yes, and the cognizance order, my lord.
So what is wrong in the charge sheet and cognizance sheet? Tell me.
That's what, my lord. First of all, my lord, initiation of the, my lord, this FIR after,
Itself is wrong. You are saying the initial FIR is
that's the,
itself
my lord,
wrong.
prime submission.
And it has been done on the basis of an inquiry which has been sort of interfered with
Yes,
by the High Court, because High Court has stated that a fresh inquiry should be done.
right, my lord.
So you are saying that
They can go for fresh after getting a fresh inquiry report.
No,
If
that-
something
that-
there, they can go.
that is why I was asking
Yes,
that yes, fresh inquiry has been directed. Now you tell me that whether the I mean only because High Court has directed fresh inquiry
right, my lord.
and departmental press inquiry, obviously it will be done.
Yes.
But whether they are stopped from filing any FIR.
They are not on the basis of the fresh inquiry report, because
No,
so for
before
this
inquiry, before inquiry, whether they can file or not, you tell me that.
my lord, in my humble submission to this answer, my lord,
No,
this
no,
inquiry report.
no, if there is an allegation of some kind of corruption in a department, correct?
Yes,
Now, department has two things department can do. One, a department can obviously go for initially only they can file
Right,
an
right.
FIR,
right,
or they can go for departmental inquiry, or both they can do. They can
Right.
file an FIR and they can go for departmental inquiry also. Now, in your case also, they have, though fresh inquiry has been asked, they have filed an FIR because they have some certain material already on their end.
my lord, I would have, my lord, considered to that, but I cannot.
But
On
inquiry
the
report,
ground.
see, inquiry report is not nullified.
Because that report will not be accepted in my humble submission in the, my lord, trial, which is the prime document. I will place before the trial also, my lord, that inquiry report, this inquiry report cannot be
The
taken.
police will do their own investigation, independent investigation.
My lord, here is
And
a,
thereby they have filed
here
this
is a,
charge sheet.
here is a catch, my lord. Now kindly see. Had there been the FIR instantly in the said period, 2020 to 23, my
There
lord,
was a mistake committed by them.
this mistake is, my lord, costly.
No,
as
whether that's what
costly.
I'm asking.
Because this is
Then you
the
show me.
informant.
Then
Yes.
you tell me that like that this filing of the FIR
Yes,
in a belated stage
is not bona fide.
is fatal.
On the ground, that, my lord, the informant is not an ordinary person. He is a responsible government officer under secretary to the, my lord, PSC department. His duty is to obey with the order of the honorable court also. So far, the lodging of the FIR is concerned. If it could have given a loss earlier, I would not have come, my lord. It has directly violated the judgment of the honorable court. Majesty of the court is to be, my lord, upheld. Now, in my all humble submission is that, my lord, if initiation of the action is bad, in not in accordance with the judgment or the, my lord, law, then the all subsequent renders bad. They can, what is the hurry? They were sitting over in the matter from 2023 to 2025, and that too, kindly see there, my lord, courage. That too after interference. My lord, had they not gone for, they have gone for the fresh inquiry. After lodging of the what's for, my lord? So, take the fresh inquiry report and put me behind the bar. This is the, my lord, one submission. Next, my lord, lordship, there's one judgment 2011, my lord. 2011, 14 SCC 770, my lord. Here, paragraph I have given, my lord, in my
Yes,
107, 108, 109, 110 and 111.
107,
108,
108,
109,
109.
110 and 111.
Okay.
Yes. Here, my lord, what happened? FIR was lost, and during the, my lord, investigation period, one accused, he escaped. And after acquittal of everything, the High Court directed, Patna High Court directed so motu to lodging FIR against him. That was challenged. My lord, in the initial case, my lord, order, there was a timeline. 20 years from the High Court, they can take up this. Yes. High Court has taken a so motu against the, my lord, escaped person. Then the Honorable Supreme Court said, my lord, no. Case has been acquitted on benefit of doubt. What you will get now? Thereafter, even there was, my lord, there was another petition filed in the division bench also, that for searching the, my lord, corpus of the missing person. My lord, in that case, the Honorable Supreme Court said, my lord, 105. My lord. Or I didn't read also, my lord. The FIR unquestionably is an inseparable correlate to the impugn order which are nullity. Therefore, the very part of FIR which is direct consequence of impugn order cannot have any lawful existence. The FIR itself is based on a preliminary inquiry which is then is based on the affidavit submitted by the who had filed the petitions under section 482. The order impugned has rightly been challenged to be a nullity at least on three grounds, namely judicial was want of jurisdiction to by virtue applicants of the provision 362, coupled with the principles of constructive res judicata, and the bench had not been assigned the roster to entertain the petition under 482. The entire judicial process appears to have been drawn to achieve a motivated result which we are unable to approve of. It is settled law position that if initial action is not in consonance with the law, all subsequent consequence proceedings would fall through for the reason that illegality strikes at the root of the order. In such a situation, the legal maxim sub leto fundamental credit opus, meaning thereby that the foundation being removed, structure works false, come into play and applies on the all scores in the present case. So in so case, this court observed that once the basis of the proceeding is gone, basis, my lord, all consequential actions order would fall on the ground automatically, and this principle is applicable to judicial, quasi-judicial administrative proceedings equally.
So you are saying that like since inquiry report has been, interfered with, so the basis has gone. So there cannot be any FIR on this. This is what you are saying?
Until and unless you get a fresh inquiry report pursuant to the judgment of the court. Had there been the FIR before the judgment, I would not have. Absolutely violative.
Okay, your argument is that like
That's
since
my-
that inquiry, let us see the judgment of the single bench order direction.
All right. Madam, before that, let me complete one judgment, madam.
On what which point?
On the ground, my lord. Here, my lord, the honorable court, High Court directed to complete the investigation within a period of 8 months to complete, while allowing the, my lord, quashing application. Directed for fresh inquiry, whatever, to the vigilance, 8 months. There, my lord, they have completed beyond 8 months, 3 of 4 years like that. So in that context, while made a challenge before the Honorable Supreme Court, the Supreme Court said, no, you have not complied with the order of the court. You have not completed within 8 months, which was granted. So therefore, all the FIR, search sheet and the consequent order were set aside. 2014, 13 SCC, my lord. Para 28 and 29. I will not bother. So this is a judgment.
Para?
28 and 29. My lord. You have not completed within the time granted, no? My lord, 29 directly. No?
That's why we want to see that High Court's
Right.
order.
Yes. Order of the judgment of the Honorable High Court, my lord. It is at 43. Para to inquiry initiated, my lord. My lord, para 4 is the my lord, SARS in the my lord, my lord. Well, absolutely, my lord, violated Rule 9 of Assam Service Disciplinary Rule, my lord. Therefore, directed for fresh inquiry. Court has not stopped that. They have the liberty, my lord. Now, lordship, so for explanation in the, my lord, investigation report, my lord, kindly consider page 33, my lord. Page 33 is the, my lord, report of compliance. My lord, report of compliance was, my lord, submitted by the executive engineer, my lord, the junior engineer page. And, my lord, page 34 is the, my lord, letter of allotment. That letter of allotment, my lord, junior engineer PhD. I have not issued those.
Yeah, these are matters.
Materials to be there, my lord, find
No,
out there.
these are different matters, but like
Correct.
you're arguing your case based on something else.
Not proper. Initiation is not proper.
So your basic argument is that that inquiry report and this thing.
Correct.
Because these are matters which
Yes.
are not required for
Not
this
required.
for adjudication of this
Absolutely.
case.
Obligement.
Now only so see one inquiry was there. You are saying that inquiry was not done as per the service rules, and then you have not been given any opportunity. So honorable court has come to a conclusion that inquiry is sort of bad because because no opportunity was given to you. So a fresh inquiry should be done, but you have been reinstated because the inquiry was they said that the inquiry was not conducted properly.
Right.
Correct. You have not been given any opportunity of hearing also.
Right.
And only on the basis of the inquiry report, you have been terminated.
Right.
So that's why you have been reinstated. But saying that, but court said that taking into account the facts of the case. So I mean, though you have been reinstated, but they have a liberty to go for a fresh inquiry.
They have gone to.
Correct. Now your case is that in spite of that direction,
Yes.
now they have given you a so called notice, but in the meantime, they have filed an FIR,
FIR.
which they had not filed earlier,
Earlier.
and they had filed the FIR only. They have filed the FIR only on the basis of the inquiry they had conducted earlier.
Right.
That is your case.
That's
Because you are saying that like copy of the inquiry report has been forwarded along with this FIR.
right.
Hmm.
Absolutely. That is the case, my lord. Therefore, my lord, in view of the 2014 judgment, my lord, Sir Ashok Kumar Singh, my lord.
One second. Yes.
Therefore, my lord, as is in the case of the Ashok Kumar Singh, my lord, 2014-13 SSC, my lord, page 81.
Which one? These are that one you have given?
2014, my lord. I have given, my lord, that judgment. Yes. Here I just para 28 to 29, the honorable court said, I court said, okay, you complete the para 3 kindly see of this judgment.
Para?
Para 3, my lord.
3.
Yes. On the factual part. The first respondent at the stage of file a writ petition, so-and-so Patna High Court, challenging an inquiry. The same was disposed of with a certain observation. The observation made by the High Court, having not complied with, a contempt petition was filed by the first respondent Patna High. It was disposed of with a preemptory order to dispose of the inquiry within 8 months. They have not, my lord. Para 14, my lord.
No, correct. In that case, there was a direction to conduct fresh inquiry.
Fresh inquiry.
I mean, they have not completed within 8 months. They have done it
Yes.
after 4 years.
After-
So you have challenged their inquiry report saying that like, they have taken it 4 years.
My lord.
I know. Was there any other ground of challenging that?
Like here in this case particularly that on the same ground only, because para 29 is while setting aside on this ground only, you have not completed within this period, therefore set aside. Entire thing.
But how is this relevant to your case?
So far relevancy is concerned, my lord. This court of order passed by the High Court is the order to be
See,
obeyed.
order passed by the High Court to conduct a fresh inquiry. How much time they have given, High Court has given?
6 months. My lord.
6 months. And inquiry is completed or not?
Inquiry is not complete.
Not completed. Yeah, I mean, not completed. Well, I mean, you have filed this petition when?
I have filed this petition.
Did
my
you
lord.
get any stay?
No, my lord.
You didn't get any
My
stay.
lord, the stay was supposed to be considered on returnable date, my lord.
Hmm.
However, Lordship on the last occasion wanted to dispose of this matter
Correct.
without going for the stay.
Okay.
So I
So-
filed it on 11/5, my lord.
So you are
Because-
saying that like inquiry should have been completed within 6 months?
And on the basis of material available, you can lodge the FIR because the FIR which has been challenged, there they have, my lord, there is no independent, my lord, allegation in the
No,
FIR.
no. See, come one by one.
My lord,
See, this case, you are relying for what? You are relying for this case,
timeline,
saying that like, see, in your case also, High Court has granted 6 months time.
right,
Inquiry has not been completed till date, correct? And in this case also, within 8 months,
Right.
it was there in 8 months. And since that was not completed, within that period, it was quashed.
right. And I want to bring
proce-
the analogy,
And proceeding of which was proceeding of departmental proceeding was quashed.
vigilance, my lord, that vigilance
Vigilance.
in vigilance PS case, my lord. Vigilance investigation was quashed, my lord. Para 6, that after para 3, my lord, then
So you place your facts properly there, Mr.
Yes.
Das. Then it will help your case, but you are not placing the facts properly. So
Hello.
it was here also a vigilance case was.
vigilance case was there.
No,
On the
vigilance
basis
case
of
was
plea-
there from the beginning.
Yes,
Vigilance case was filed and department proceeding happened.
my lord,
Then there was a department proceeding, inquiry was submitted. The
submitted.
inquiry was challenged.
There, my lord, they have not finalized the inquiry.
Hmm.
While filing the contempt application, the honorable court said, you complete the inquiry whatever within 8 months.
Hmm.
They have not completed
No, initially they came to the court forward,
for passing the FIR, my lord.
passing the FIR.
Yes,
Then said that, court said that if it is of the inquiry,
yes,
hmm?
yes.
Which were are you showing?
My lord,
On the basis of para 6, on
yes,
the basis of a detailed inquiry, the vigilance so and so,
because case is of 1996, my lord.
so no, I understood that, see, there was an inquiry earlier.
Earlier inquiry was there.
On the basis of that vigilance case was filed.
Right,
So he placed the facts properly. There was an inquiry, then on the basis of a detailed inquiry, vigilance case was filed.
right,
Then vigilance case was challenged,
yes.
correct? Then what happened?
Then, my lord,
Then court's finding was what?
courts directed to complete the inquiry within certain period, 8 months. And the vigilance has not completed, takes so many years.
Vigilance case was stayed was in abeyance or what?
Vigilance case was finally, my lord, quashed, my lord.
Finally quashed, but
Finally,
at
in
that
the
point of
meantime,
time,
there
what-
is no mention, my lord, staying, my lord. Page 6, para 6, my lord.
that's what I'm reading.
This vigilance PS case was raised on the basis of inquiry report which was obtained much after the period stipulated by the honorable court.
No, that is fine.
So far, I am concerned in this case, I want to bring this analogy, Lord, saying that you have not initiated the criminal proceeding or lodging FIR, and that in the FIR there is no independent allegation, only forwarding the reports. Had there been independent allegation in the FIR, kindly Lordship again, if Lordship allow me, page 71. There is not a single allegation, my lord, of misappropriation of government fund. This is only a forwarding of the report, page 71, my lord. Had there been any allegation of misappropriation, then I would not have come for quashing, my lord. By this FIR, they have forwarded the inquiry report. And pursuant to the judgment of the court, you have initiated a fresh inquiry after lodging the FIR 23-5. In the meantime, you have already lost the FIR. So, my whole argument is that, my lord, initiation of the inquiry in violation of the High Court order is bad in law. If initial action is bad, all subsequent action renders illegal, liable to be interfered by the honorable.
Okay,
Precise submission.
Okay, let me hear him. Yeah,
My
there is a-
obliged.
Maybe, no. In this case, my lord, your lordship will
See,
find.
earlier inquiry has gone.
Yes, ma'am.
Earlier inquiry has
No, no,
gone.
no, there are two parts, your lordship.
Hmm.
Just for fault. The deputy commissioner, he conducted a fact-finding inquiry.
Hmm.
It was merely a fact-finding inquiry,
Hmm.
madam, and it was sent to the government for taking necessary
The
action.
government has dismissed him.
No, that part is illegal.
Hmm.
But so far the fact-finding inquiry report is concerned,
Hmm.
that has not been interfered by the High Court.
The High Court doesn't say anything. The High Court says that inquiry.
Inquiry, department inquiry.
It's our department inquiry.
Not fact-finding inquiry, but in fact-finding remains there, madam, where it is. Madam.
How it will be staying?
Your lordship may kindly see the judgment of.
No, no, let us see this single bench's judgment.
Yes, I'm coming.
Which paragraph?
I'm coming. 43 it starts, my lord. Now your lordship will find that the fact-finding inquiry, my lord, it was representation challenging so. That was report dated 4/4/2022, my lord. Inquiry report.
You show me where it has been discussed.
Discussed.
See, your argument is that there was a fact-finding inquiry by the DC.
No, it
And
was
on the basis of the fact-finding inquiry, when it was sent to the government, government has taken a decision. The government has not gone for a departmental proceeding. That has been interfered with by the court.
because
But you are saying that like the government's action of not going for a departmental inquiry is not good. That's why it has been set aside.
Set aside,
But as far as fact-finding issue is concerned,
yes, my lord.
that fact-finding is already there.
It's already, but
It's already there.
it's already there.
When this FIR has been filed on the basis of the fact-finding, that's what you're saying.
Yes, FI was simply fact-finding, inquiry report was forwarded to the.
So where is it? Where has it been discussed?
Yeah, your lordship may kindly see. Page 45, my lord.
Huh?
Page 45, my lord.
Page 45.
Oh.
Yes.
In the case of petitioner, he was not afforded opportunity to present his case or produce evidence in defense. On the contrary,
Now where reading page 45?
paragraph 5, my lord.
Paragraph 5, yes.
It is the case of the petitioner.
Hmm.
He was not afforded any opportunity to present the case or produce evidence in his defense. On the contrary, on 27/4/22, Deputy Commissioner furnished a copy of the inquiry report dated 4/4/2022 to Additional Chief Secretary, holding the petitioner guilty of misconduct, embezzlement of public money. Based on such report, Impugn Order 412 was issued, whereby dismissing the petitioner from such without holding a departmental proceeding as per law. It is specifically pleaded the petitioner before the Impugn Order measure points and that regarding Rule 9 has not been complied with. That has been discussed, my lord. Your lordship will find. They're from service.
So Rule 9 is what?
Really procedure of this is disciplinary proceedings, my lord.
Correct.
That has not been followed. That I agree, my lord. That correctly it has been done, my lord. Now, so far that now court has interfered with the order of dismissal. my lord.
Now the thing is that like fact-finding inquiry, you
Yes.
have done a fact-finding inquiry on behind his back.
Yes, behind his back. Yes.
Behind his back, you have done it.
Yes.
Then on the basis of this, some inquiry, some disciplinary proceeding, without holding a disciplinary proceeding, you have dismissed.
Article 11(2), my lord, that was
Correct.
passed.
So you have dismissed it.
Yes, my lord.
So how this fact-finding inquiry will stand?
No, because court has not interfered with a fact-finding inquiry.
No, court has not commented on anything on this.
The court says simply the origins stated above.
See, this says, this paragraph 5 only that you have written.
Now, your lordship
you have
kindly come.
read.
Finding
The
of the court.
impugn order was issued no, based on such report,
Yes, my lord.
based on such report, the impugn order was issued.
Yes, my lord.
And impugn order is gone. Correct?
Yes, sir.
So if the basis of on the basis of which the impugn order was passed, that has gone.
Not,
So
not the
then
basis. Order was gone.
That correct.
Yes.
That order was passed on the basis of what?
Because there was no opportunity was given to the petitioner.
That is
I
what-
understand.
so here also, I mean, this fact finding was done behind his back.
Well, the fact finding is just for appraisal for the government, my lord.
That cannot be.
Now,
cannot
your
be-
lordship may kindly see your lordship finding of the court, my lord.
Hmm.
There is no doubt the fact that disciplinary could empowered based paragraph 15, my lord.
Paragraph?
Page 52, my lord.
Paragraph 15.
Yes, my lord.
Yes.
Because your
There cannot be any doubt. Yes.
yeah, there cannot be doubt that disciplinary authority only empowered under law to initiate action, impose penalty,
Hmm.
or erring official, including major penalty,
Hmm.
if he is found guilty of misconduct. However, such penalty can only be imposed following a procedure prescribed under rules.
Correct.
Less the same would be a peril. For the reasons stated above, court is opinion the impugn order of dismissal from service on 1412 is vitiated by arbitrariness illegality. The same is accordingly satisfied. Consequently, writ petitioner shall be reinstated back in service, having regard to the peculiar facts and circumstances, nature of, that is very important. Nature of allegation brought against the court is of the opinion, case do not justify exoneration of petitioner on such technical grounds without subjecting him to proper inquiry proceeding. As such, department is granted to initiate fresh proceedings against the petitioner from stage of issuing so-called notice to so and so. So this court has never, so far the inquiry, initial the fact-finding inquiry remains there, my lord. It has not been interfered by this court, my lord. Only the order of termination was interfered, my lord. Because termination order is illegal, apparently.
Termination order is on the basis of the fact.
But that is illegal. That is
Fact finding inquiry, and the fact finding inquiry has been done behind his back.
I understand, Mile, but order of termination is illegal on the ground because no notice was issued to him, Mile.
Correct.
So on the grounds of natural justice, it has been set aside, Mile. But
That's what I am asking. It doesn't specifically say anything.
Yes, Mile.
From reading here, you can't say. I mean, you cannot distinguish this, but you may, as a lawyer, you can try to distinguish it. But there is nothing on the. I mean,
I understand, Mile. After all, it's a fact finding because there is preliminary inquiry. You can also make a see.
Now, on the basis of one preliminary
inquiry,
one decision you have taken. See, government hasn't done any separate inquiry, right? Only on the basis of the
preliminary inquiry, yes.
Preliminary inquiry. Now, court has come to a conclusion that that inquiry, termination is bad because inquiry was done not properly.
Because no notice was issued.
No notice was done. Nothing discipline proceeding was.
No, yes, that order. But so far the veracity of that inquiry report has not.
It was not discussed in this case.
No, that was discussed.
Not in this case. So we cannot presume or assume anything.
Yes,
on the basis of that.
Now, government has forwarded the said inquiry report to the CM Vigilance Cell. What CM Vigilance Cell has gone for a fresh investigation. We examined more than 70 witnesses. We examined the labors. They said no work was executed. The society doesn't exist. Him society, my lord. It doesn't exist, my lord. In paper only is there, my lord. And whole amount has been misappropriated. And he was this executive engineer as well as the assistant executive engineer, accounts officer responsible. And it was, and money was routed to one Jiaur Rahman, my lord.
But correct,
public money has been already, and different NGO has executed enough works. This NGO will no way collected with his works money. Never allotted, my lord. Nothing. Not a record, my lord. All on basis of forced documents, this has been done, my lord. Just misappropriate government money, my lord.
But correct, but that is true. I mean,
because we are not relying on that report. We have gone to a thorough inquiry.
That may be correct.
Because in the case that I have marked it, my lord. The statement of witnesses have clearly stated, my lord. How the engineer, how he has done it, my lord. Manner in which he has passed the bills, my lord.
But only thing is that, like, whether, I mean, the legal issues, see.
I understand, my lord, but since now, had it been at the earliest point of time, he would have come better definitely. Now, search it has been submitted, cognizance has been taken. And it's a case of conspiracy. Not only him. There is the assistant executive engineer is also involved. Accounts officer is also involved. Another private person is also involved. Whose account the money has been diverted, man. It's a clear case of conspiracy. Forged documents. And an expert opinion is also there, man. How it has been conspired, man. After all, it's a public money, man. That has been misappropriated.
CD is with him. CD is with
yes,
him.
CD is. I marked it, my lord. Oh, no, they did voluminous one.
And that we'll see, we'll see little later. And anything else, Mr. Pototi, you want
No,
to?
basically, that is the since investigation, because we are not, no doubt it was initiated on basis of inquiry.
No,
but
no,
we-
his primary ground is,
Understand, madam.
primary ground is that FIR has been lodged on the basis of an inquiry which is actually been interfered by this court. And had it been like with some fresh material, FIR would have been filed, he wouldn't have any problem.
Understand, madam, but
So that is the thing.
now that was the FIR was lost, but that was in case of 25. Or immediately would have come matter, there is a stay in the proceeding matter of event. Now, since it has gone, and we have visited the place of occurrence, we went to place of site, we have taken photographs.
And another thing, he's saying that like 6 months, within 6 months, you should have completed, you have not done it as yet.
No, 6 months is not so far.
Oh, so not for you.
No, no.
6 months is for them.
What of department proceeding?
For a department, what are you doing in the department proceeding?
Lordship, that's instruction I don't have, Lordship.
Then why you have why you have appeared before this case?
Lordship, I have appeared in this case as in personal capacity.
The personal capacity also, I mean, he's the person who has he has done it.
Lordship.
So like without instruction, why do you come for the hearing? I mean, these kind of questions you are expected, no? What has happened to the department proceeding? He has taken a ground. Have you gone through the brief or not?
Lordship.
Then I mean, how you can come and like say before this court that I don't have instructions after hearing the whole matter?
So far that instruction is concerned, page 63, I have stated, they have given a fresh inquiry, and that fresh inquiry interpreted again by the Honorable High Court. Then, my lord, another inquiry, the court said that you comply with the judgment, give opportunity, then you issue the page 63. Again, inquiry has been given, and that page 67, this has been stayed.
So that's what I was asking, what is happening there?
Yes, this is stayed.
Mr. Counsel, I mean, you should come prepared, not like this. This is not expected. I mean, you appear for, somebody and like, I mean, you do not read the brief. It is there in the brief itself. So, Mr. Das, you cannot now, I mean, say that the inquiry is not completed within 6 months. How can you say that?
This is the process of the court, my lord.
No, correct now. You are arguing on to saying that you are showing this.
It will be different.
No, not different. You are saying these two cases, relied on these two cases, saying that since inquiry was not completed within stipulated time, the Honorable Supreme Court has quashed both the FIR and the thing. Both the FIR as well as the departmental proceeding. That's what you have said.
Yes.
That is the case you have relied on.
Facts are concerned, I placed on the basis.
No, I mean, see, Mr. Das, I mean, now there is a stay order from the, that's why I was asking you
No,
that whether, I mean, what has happened to that? And at that point, we didn't say anything.
My lord, my prime, argument is that, they have not gone for the fresh inquiry prior to lodging on the FIR itself.
That is a different
is the
thing.
ground.
That is a different thing. That I'm not, that ground, fine. That ground is on a separate footing. What I am asking is that like the cases you have placed,
Yes.
those are on different footing than your case. Your case, I mean, they cannot complete the departmental proceeding because there is a stay.
My lord.
So how this case ratio will be ratio you can apply to this case, facts of this case?
That's correct, my lord. That's so far, my lord.
No, Mr.
No.
Das, Mr. Das, see, in those cases, there was no stay.
No.
So departmental proceeding was directed to be completed within 8
Particular
months. Contempt was filed. Then contempt case was disposed of, saying that like you finish of the department proceedings within
Precisely.
8 weeks, right? 8 weeks or 8 months. Then the department could not do so. They have done it after 2 years or 3 years. Then Honorable Supreme Court said in that context, in that circumstance, the Supreme Court said no, or the everything is bad because we have not complied with the High Court's order. That was the issue there.
Yes.
But in this case, there is a stay order pending. How can they complete it? So how this case's ratio of this case will be applicable to this case? So you convince me.
Yes,
We are ready to hear you.
understanding on this, my lord, that without going for, because 23-5, you have gone for the fresh inquiry. However, that has been stayed or set aside is another thing. You have gone on 23/5/2025, and prior to, while making a mind to go for a fresh inquiry in compliance of the judgment, what has influenced you to lodge the FIR prior to that 25/25? That is my argument. On this context, my lord, I was pressing.
But that is not applicable to your case.
The
Case is not applicable.
facts will definitely.
That will not applicable. I mean, those cases. Basically, I mean, those FIR was lost long time back earlier.
Because I was called only in December, my lord. I have annexed.
No,
that
no,
copy, my
in
lord.
those cases, FIR was filed
Yes.
earlier, departmental
yes.
proceeding was not completed.
Right.
Then FIR was stayed, then he said they like complete the departmental proceeding. That is one thing.
I will be, my lord, trying to convince your lordship on the another ground, saying that, my lord, my lord, that you cannot take two stand. Either you go for you go fresh inquiry, and you have gone. Why you have gone? To get a fresh inquiry report. On the basis of the material available, you will forward. And in the FIR, there is no independent allegation. Had there been independent allegation, then I would not have proceed, in fact, before this honorable court. Since there
See,
is,
Mr. Kotoki is now arguing that this, your case, I mean, that honorable single judge has passed the order only on the ground that departmental proceeding was not conducted as per the service rules. He has not said anything about the fact-finding inquiry of the DC. Nothing has been said about
that is the basis.
No, wait. He said that on the basis that is there, but with that he should have gone for departmental proceeding. Correct. With that you should have gone for this. So you have not gone for this. You have come to this stage, but from here you should have followed a different route. But you have not followed a different route. Here only he stopped and he passed an order. So that is wrong. You should have followed this route. Correct. That is what he is saying, isn't it?
Yes, my lord. It remains, the inquiry report remains, my lord.
So he says that fact-finding inquiry remains. But only thing is that after the fact-finding inquiry, you should have gone for a proper disciplinary proceeding as per the rules.
Rule 9.
My lord,
Rule 9.
yes, my lord. To answer that, my lord, query, my lord, had the honorable court directed for interference from the stage of issuance of the impugned order, dismissal, then it is another thing, my lord. What is the direction, my lord? The direction is that go for fresh inquiry.
Departmental inquiry.
Because departmental inquiry has been forwarded, the materials is on the departmental inquiry. So as of now, whether can we, my lord,
See, another important thing, I'll just point it out.
Yes.
I think see, I mean, here one line is important. It is the case of the petitioner that he was not afforded any opportunity to present his case or to produce evidence in his defense.
Yes.
On the contrary, on 27/4/22, the Deputy Commissioner Nalbari had furnished the copy of the inquiry report dated so and so. So you have that copy with you.
Yes, madam.
That inquiry report is with you. It's not that like, I mean, the inquiry report, I mean, you have not challenged that inquiry, I mean, that fact-finding report. Have you challenged that?
Lord, that is discussed in para 14. I have challenged in this repetition.
No, in this petition.
Yes, I challenged, my
you
lord,
have
because para
challenged
5,
what?
para 5 read with para 14, my lord, it is discernible, my lord.
What, 14?
Yes.
Okay.
Because initial.
One second, read 14.
Please. In so far as the so-called notice that 13/6/2022 is concerned, it is no doubt correct that the said notice can be treated as a notice in its departmental proceeding against the petition. However, this court has noticed that before initiating such departmental proceeding, petitioner was not given an opportunity to explain his conduct. The failure of departmental authorities to give an opportunity to the petitioner explain his conduct, the considered opinion of this court, indicates a predetermined mindset of the disciplinary authority to come to a conclusion even before holding a proper disciplinary inquiry on the charge of misconduct brought against him, the writ petition. Permitting such a recourse, opinion of the court, it would not only run counter to the scheme of Rule 9, 1964, but would amount to extending complete unfair treatment to the petitioner. That is there, my lord.
There is, so nothing has been said about this.
So far the report mentioned in paragraph 5, my lord.
Correct. What does it say? 14 says what?
So therefore, they
Oh,
have
no.
to start the inquiry from the stage of giving opportunity from the stage of the initial inquiry, in-house inquiry report.
No.
Therefore,
Departmental.
the subsequent inquiry was interfered, and the stay is for that reason. Lordship, kindly have a look, my lord. The judgment.
So departmental authorities shall frame definite charges on the basis of allegations. So those things has to be done. Those things were not done.
Not done,
So that's why it was interfered with.
my lord.
But as far as this fact finding, inquiry is concerned,
Yes.
how that is going to, how that is going to,
Affect me, my lord.
affect me, affect you, no? Like where you have to challenge that.
My lord, yes, that was otherwise challenge. Now,
Where?
my lord, thing is that, my lord, the honorable
No,
court says,
I mean,
state, my lord,
no,
without getting.
whether this court, this coordinate bench, while passing this order, has come to a finding that that is also bad. But in fact, para 5, it has said that the copy has been given to you.
My lord,
You have not challenged that. It has not been stated that it has been challenged also.
that is
It only says that you have challenged the measure penalty.
measure penalty as
Measure
well as
penalty,
two inquiry report.
Measure penalty without.
My lord, this is, my lord, somewhere para 5, it is, my lord, clear, my lord. And because the interference is that, my lord, at least to give the scope for, my lord, of being heard.
That is
To
why.
explain my conduct in the
no.
preliminary inquiry, no notice was given. This is the prime ground on which, my lord, interference has been made. From the stage of initial inquiry, in-house inquiry. And not to speak of the, my lord, departmental inquiry, no opportunity. And therefore, subsequent that I already pointed out, subsequent that page 63, inquiry they have issued. My lord, they are also, while staying the judgment, my lord, inquiry so cause, page 63 is the order by which stay was granted, my lord.
Yes, where is the order?
Yes.
Stay order.
Page, my lord, 68, order dated 6/8/2025. And
Actually, my lord, what happened, my lord, earlier court, my lord, the coordinate bench is directed to issue explanation, my lord.
Yes.
If the explanation is
Nothing.
not satisfactory, they can go for so-called notice, my lord.
And here
That
they are
part-
taking time
Hmm?
for filing.
That part was not followed, my lord. Without issuing the explanation, they issued the so-called notice.
Every time they are making the mistake. And here in this case, my repetition, they are taking time for filing affidavit, my lord.
That is a different.
Hmm?
It is not for us that the repetition is pending. It is the department who is seeking time for filing affidavit of opposition. This pending. This is not that, my lord, something is on our fault, this is pending. my lord.
I like to some decisions, my lord, regarding department proceeding, my lord.
No, one second. You were superintending engineer at that point of
Yes,
time.
yes.
Hmm?
Executive
I
engineer.
have retired, my lord, now.
Now, at that point of time,
At the point of time, executive engineer.
executive
my lord,
engineer. This page 75.
Yes,
This was the initiation, right?
yes. And the report is of dated 4/4. Lordship will find the report that on page 80. 4/4. That report is mentioned in the para 5 of the judgment, my lord.
No, they said that it has been given to you, but you have not challenged this report.
That is a challenge.
You have not challenged where?
Because this was mentioned in para 5.
Para 5 says, I mean, that has been given, we are not given, your argument was it was not given to you.
Yes.
But court found that no, it was given to you.
My lord. And therefore, my lord, from the stage of in-house inquiry,
You
that
see para 5,
opportunity was directed.
para 5 says that petitioner was not given an opportunity to present his case or produce evidence in his
That
defense.
punished.
On the contrary, the deputy commissioner have furnished the copy.
Yes.
That means what?
That means, my lord,
That means like you have not challenged that.
I have enclosed with the
No,
repetition.
you have enclosed it, but you have not challenged it.
No, 4/4 it is under challenge.
Huh?
4/4, my lord.
No, it
Four-
was not challenged.
4/4 is under challenge, my lord.
Hmm?
In my all humble submission.
Which was what?
That third line, my lord, is dated 4/4/2022. This is the report. That report was mentioned, page 80. This is a report of 4/4/2022.
Correct. So where is it? Where do I find out that you have challenged that? And court has set aside that. The inquiry is bad, that preliminary inquiry is bad.
Court has directed to grant the opportunity from the stage of in-house inquiry.
Not in our own, department inquiry.
Now he can do subsequent one stay কৰিছে.
সেইটো তাৰপিছত stay কৰি আপোনাৰ হেৰি দিয়া নাছিল।
Affidavit নিদিয়ে।
Explanation বিচাৰি explanation দিয়া নাছিল।
Yes. You wanted to say something?
No, the inquiry report was forwarded to him, but he has not challenged in the report proceeding. He challenged the order of termination, my lord. And that was set aside, my lord, because no opportunity was given. And ultimately, this
But is it allowed to do any kind of inquiry against an employee with behind your back
no, that was a fact-finding inquiry.
without giving an opportunity to him?
No, actually, we have apprised the government to take necessary action in accordance with law. But government, without following the procedure, they have done it. Now, how that inquiry officer is responsible, my lord?
Hmm?
It was only a fact-finding inquiry informing the government about the illegality, my lord.
No, whether whether that will stand.
No, that was never challenged, my lord, because it was never challenged in the proceeding, my lord. And on the basis of that inquiry report, illegally they have issued without show cause notice, he was terminated. And that order of termination was set aside. And honorable court directed that go for fresh inquiry. Explanation should be called for initially. If the explanation was not be found to be not accordance with law, they may go for departmental proceeding. That clearly laid down. The second inquiry also did without calling for explanation, immediately they went for inquiry. That's why it has been stayed, my lord. So there is a fault of the department. But so far the government is concerned, the alia inquiry report, which was this fact-finding inquiry, was forwarded and it was a thorough investigation was done there. He appeared before, his statement was also recorded, my lord. In that our investigation, I have recorded statement is there.
Where statement recorded?
In investigation, doing investigation. My
This is investigation.
yeah, no, in police investigation. Because your lordship has granted anticipatory bail, he appeared before us. Other officials also appeared. Their statements were also.
That is not a problem. But
Yes.
only problem is that like whether he could have filed an FIR on the basis of one inquiry, which has been kind of interfered.
But I cannot say, but actually not interfere. It is because actually it's a fact finding because it was never set aside by the court, my lord. Simply it was a basis on which it would have been proceeded with other inquiry. But that has not, because he has not challenged it also. That is illegal, whatever it is. And at no point of time it was interfered by the court, my lord. It remains at its well. And that was forwarded, and based on that inquiry, we went for further investigation, we went for fresh investigation.
See, Mr. Das, here also like in para 6 of the single judge's order, there also it says that he specifically challenged the dismissal due to violation of section 9. Nothing else.
Well, indication is so much, my lord. Indication is that, my lord.
The
While the
indication-
court is directing for, my lord, fresh inquiry from the stage of granting opportunity from issuance of the, my lord, in-house inquiry. So, my lord, that some consideration, some argument was considered on the basis of this direction was granted. Merely without challenging, my lord, this direction cannot be given for go for fresh inquiry. So, my lord,
No, fresh
fresh
inquiry-
inquiry speaks, otherwise, my lord, what is the fate of the earlier inquiry report? Why the honorable court wants a fresh inquiry, my lord?
See, the initial inquiry was not done by the department. It was done by the person who was the chairman of the committee.
Right,
Right? He's a DC.
yes.
DC has done the fact finding.
And he has, my lord, approved the file.
But he has done.
He is not the accused.
He has done the fact finding.
Yes.
Whatever he has done the fact
He will
finding.
be there.
All these things he have not. Challenged those. He should have challenged those that like he is also a person who was in the committee who was responsible to approving these bills, and he is doing the fact finding.
Yes.
Fact finding. You have not challenged that.
And this is their domain, my lord, whether they can go for against the DC or not, because I have given the scheme.
No,
Other
you-
how?
See,
This
you had
runs.
a very easy case. He could have said, ki, like DC being the part of the approval committee, how can he conduct that fact finding inquiry?
My lord, page 30, this is the scheme, how it runs, my lord. And page 31, chairperson, deputy commissioner.
That is why
Of-
I'm telling you that why you haven't challenged that. You should have challenged that.
They're covered by even high ups, my lord.
I mean, the court is not going to cover anybody. No? So he could
Well,
have-
as per law,
he
madam,
could
that's
have-
I
he
understand.
could have always come to the, he could have
Yes.
always approached the court.
And
That he
there
have not
is-
done so.
And there is so far, my lord, there is no explanation as to how they caused the delay of lodging the FIR. 2021, 2023 check period, and this is you wait for 4 years.
They thought they are very intelligent people that they have lot of wisdom, these officials.
This is
So
the
the,
place where the
They thought,
should be
they
nip
thought
in the
we have
bud.
done an inquiry, we have dismissed it. Kam khatam.
My only submission that, my lord, the order of the honorable court has not been followed while directing for fresh inquiry. Before that, you have gone for.
No, that is again, I'm saying you, which order is not followed by the department?
My lord, their own conduct.
They
On
have,
23/5, my
now
lord.
it is state, what can be done? Now this is state by the court, you have only approached the court, it is
No,
state.
No, I'm not submitting on the timeline. I'm submitting on their action, how they have deal with the case, losing the affair. My lord, they could have lost. My lord,
I said, nah, because they have a lot of wisdom, so they thought ki it's not required.
that has to stand on the scrutiny of the honorable court, my lord. Because what is the fate of the earlier report now? This will, whether that will be taken as a evidence. This is the prime document, my lord. On the basis of trial is to go. If there is no wrong, why a person should face the criminal trial like this way? If so many loopholes are there. So some protection may be there, my lord, in favor of the petitioner also. This is the prime document. What they will do if there is contrary to the
No,
inquiry report tomorrow.
I'm not commenting on anything, but what I'm saying is
Tomorrow, my
that,
lord.
no, what I'm saying is that I mean, the problem happened here because you did not challenge that order, inquiry at all.
But that may be then verified from writ petition if, my lord, my submission is that, my lord. I have challenged, my lord. My lord, 2 inquiry report and the termination order. Without challenging the inquiry report, my lord, I cannot directly challenge my lord, termination order.
No, you can. Why you cannot?
No, my lord.
I mean, there was no notice given to you. Section 99 was not followed.
So therefore, that reference has come from the annexer there.
Yeah, I mean, see, the honorable court has
And that is under challenge, my lord, in my whole humble submission.
Very basically, it is been stated.
My lord, that
And
is-
if you have challenged also, there is no comment on that by the court.
No, my lord. So far that is
I mean,
concerned.
there is no comment on that. Only thing is that court has, court has only set aside the termination and asked the department to go for the fresh inquiry. See, it is specifically pleaded case of the petitioner before the impugn order dated 14/12/2023 imposing so and so.
Yes.
Imposing major penalty of dismissal for service was issued. No inquiry within the meaning of Rule 9 of 1964 was conducted. So you are saying that inquiry, whatever happened is not in terms of Section 9.
And to be read with para 14 and 15, my lord.
14, 15 I have read.
Yes. So therefore, my lord, directed to grant opportunity.
So that inquiry, I mean, whatever, on the basis of that inquiry, you cannot be terminated. That's what court said.
That's in sum and substance, my lord. My lord, argument is that, my lord, had there been an independent FIR alleging specifically in the FIR itself, then it is another thing. I cannot challenge because FIR contains the allegation. Here, my lord, FIR forwarded the report, culminated to direction from the honorable court to go for a fresh. So this is the, my lord, my argument on the basis, my lord, I pray, my lord.
Okay.
My lord.
You have anything to say?
My submission is that the inquiry report is still there and the allegation remains the same.
Same
Not
thing.
challenged. Only the termination order has been challenged.
Hmm.
Because proper procedure. Rule 9 has done confirmed.
When the court will comment.
And then the only court has already observed that after giving opportunity, the charges should be framed against him. Explanation should be called for. And that has to be complied with. But the inquiry report remains fine. And that has been forwarded. The police, upon investigation, going for field visit, they went to the place of occurrence and found that the society doesn't exist. And on the
Decision made it.
calculated back on a different detail. So that has come on record. More than 70 witnesses were examined. Or it's the public money that has been more than 36 lakhs as municipal. No lectures has been constructed.
Okay.
Housing the solution is that that's inquiry report has been set aside on technical, nothing more. That affair has been filed. That affair has been filed to forward the preliminary report. And that is the matter of investigation by the this is a criminal investigation. There is no bar for that. But CM vigilance can investigate.
No, see, in the FIR, he is right in that saying one thing that in the FIR you have not alleged anything. You have simply forwarded that report and which has been interfered by the court actually.
Little. But
That enquiry is not in terms of section 9, rule 9.
that is on technical.
Rule 9 enquiry has not been conducted. So ask for a new enquiry. So that means what? That our earlier inquiry is gone.
There was no inquiry as such. Alia was only fact finding.
Fact finding is also an inquiry, Mr. Kotoki.
No, my lord. It cannot be inquiry under department.
The department was that's why they said clearly this is total valueless. Throw it. That is the thing. That doesn't have any value. If throw it.
But in the sense, my lord, it was only private of the government. This is the state of affairs. Because inquiry was done by the additional civil engineer. It was done by additional civil engineer. Though DC forwarded actually it was contacted by additional civil. So they have, after going through the record, they have submitted the report. And now on the basis of the report, they ought to have issued a so-called notice to him. Instead of so-called the termination order was. That was set aside. But earlier inquiry report which was forwarded to him, it was still there, man. He has not challenged. That is the problem. And that copy of the inquiry was forwarded to the CBCM vigilance cell for investigation. So we went for investigation to find out independently whether the offense was made or not. And ultimately, on the basis of that, we have collected materials and we find charges against the 4 accused persons, including the president.
Do I need to check CD for anything?
CD is there, man.
No, is there anything like which the court is required to see?
Investigation, what they have found, what are the electoral case committed by the prisoner as well as the 4 accused persons. That is there. I marked it, man. Check mark.
Certified copy search sheet I have submitted enclosing the cognizance order.
So let it be with you. If required, then like Mr. Das, if required, I will ask my court officer to
Yes,
get the CD.
Absolutely.
If required.
Absolutely.
And one decision I just aligned to place before you.
Yes, please. See, only issue now I have to decide is that whether this inquiry report, that fact finding inquiry, is still in existence or it has been thrown out.
Vis-a-vis, my lord, nothing else in the affair except forwarding the report.
That paragraph you are watching, paragraph 27 and 28. For the 6, 5, 6. 2006.
Para?
Paragraph 27 and 28.
Yes. 4-6.
27 says that executor of proclaim by criminal code is concerned in open says otherwise permissible. In the judgment, law is fairly well settled. Acquittal by criminal code regulation. The two proceedings, criminal department, are different. They operate in different fields and they have different objectives. But the objective of criminal trial is to inflict appropriate punishment to the offender. Purpose of inquiry proceedings is deal with the delinquent departmentally to impose penalty in accordance with service rules. In a criminal trial, incriminating statement made by accused to certain circumstances, certain officers totally inadmissible. Such strict rules of evidence procedure would not apply to a department proceeding. Degree of proof which is necessary in order of conviction is different from degree of proof necessary for record commission of delinquency. Rule relating to appreciation of evidence, two proceedings are not similar. In criminal law, burden of proof is on the prosecution. Unless the prosecution is able to prove the guilt of the accused, cannot be convicted. In department proceeding, on the other hand, penalty be imposed finding on basis of pre-prominent. So these are parameters, my lord. So since already trial has charge sheet has been submitted, so all the evidence has been, materials has been collected by the investigating. Statements were recorded. If he is not, and naturally, we will give opportunity, we have to prove beyond reasonable doubt. That is the material case of conclusion. He is not found in the charge sheet. So what the allegation is concerned.
No, he is challenging the charge sheet.
No, only one of that FIR part. So far, the merit part is totally silent.
No, I have said that, I have challenged that.
Merit part totally silent.
He is saying that the bills were not approved by him.
Another person. And there is no complaint that I have forced them.
No, also no.
Only from someone's mouth it has been taken that you are pressurized to issue.
Because-
And they are not the layman, my lord. They can lodge the FIR before the higher officer.
Not-
That so and so engineer has the pressurized us to issue the work order and the bills.
The question
They
is
have
that,
not done that.
but the question is that NGO, the name of the NGO is not there. It's not a register, the register of farms. Doesn't exist. And money has been misappropriated by another individual.
After DC has approved.
That has come on record, madam. And the person says that this NGO never have constructed any latrine there in the society, madam, in that area. It was done by another group of farmers. So bills are paid. That is the thing.
So you are saying that like investigation has gone properly and charge sheet has been rightly filed. So he should be allowed to face the trial.
Well, he gets the benefit, he will get the benefit, madam. By prosecution, he can demolish the case of the prosecution, madam. Naturally, madam.
How many witnesses are there?
There, I think, more than 50 to 60 witnesses.
50, 60.
These are all the NGO people, madam. They have to
But
examine.
it has not started, huh?
No.
Case is on the
Appearance stage, madam.
next that is on 27/8.
Appearances.
Appearances. Now, others we can make this by way of e-copy will be made available, my lord. So that can also expedited, my lord.
Hmm?
The copies are made available in soft copies are available.
Okay.
So the matter gets expedited, my lord. The total cited witness is
So as far as your investigation and this thing, there is no stay, so you can proceed with that.
yes, my lord.
There is no problem with that. Only thing is that like, wow, if the court interferes, then it will be different thing.
And since charge sheet has already been submitted, that's another important thing. Since charge sheet has question, now the question of passing of the FIR at this stage, belated stage, madam, is not permissible, madam. That is another thing.
Do you have any case laws on this?
I can check it and can by tomorrow I can give it, madam.
You please submit a
Yes, ma'am.
submit those cases.
Because once the rules of investigation
Once after the full investigation
That is
charge sheet is filed, if FIR is challenged in a belated way,
yes,
then what will be the consequence?
yes, that is the important.
If there is any case.
Yes, I can. Let me. I will.
Okay, we are concluded.
Yes,
yes.
Just one line, my lord. I come to know about the criminal proceeding only on page 93, 22/12/2025. They called me for interrogation. I appeared and they took my statement in December 22nd.
Hmm.
Prior to that, there was no knowledge lodging of the affair. They never called me. I have, my lord, submitted this document, page 93.
Oh, yeah, there. Okay. I have heard Mr. V.K. Das, the learned counsel appearing for the petitioner. Also heard Mr. P. Kotoki, the learned senior counsel, assisted by
And
Miss Akash.
N. Kashyap. Also heard Mr. Ali.
Deka.
A. Deka. The learned counsel, correspondent number 2. The hearing concluded, judgment reserved.
Deeply obliged. Obliged.
यार मीटर ना हो ना तब leftover कर दे will not take any more matters today. The matters will be left over and the dates will be given.
Just.
We have some issues.
Bail, pending appeal.
No, not today. Not today.
Already, 50% of conviction.
Not today. Today is not possible. Today not proceeding. I have some other works to do.
Then fix it on Monday, madam. 42, item 42.
Monday will be difficult. Tuesday, for I don't know, 42
42
Tuesday.
service report, you will complete. it.
Then my Wednesday, Tuesday, my had something. 26.
Okay, 26.
All right.
No other matters, sir.
Item number 47.
Left or will, sir?